Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. There we go. Good morning, everybody. I had a book on the button. I hope this finds you well. I hope you had a good night's sleep. I owe you an apology. I haven't even my lights on yet this morning. I have not been going to sleep until 3, 4 every night. And today, this morning was no exception. I didn't fall asleep till almost 3. And I couldn't get up this morning. I had to wake up to the alarm. I'd look at the phone, and then next thing I know, wake up to the alarm. I look at the phone, and I couldn't get up to save my life this morning. So there we have it. That's life. Things happen. Let me turn my lights on real quick. Because that sun is coming through. And the monkey's rattling the cage, which means I got to go feed her in a minute. Everybody have a good day. Everybody had a good morning. Have you grabbed your favorite cup of coffee? Are you ready for some court? I am. We are waiting for the poisoned husband Redrum trial information. So let me give you a breakdown of what's happening with Miss Corey Richins. Yes, she's in the news again. And the monkey is like, shh. So I'll have to go tend to the monkey butt in a minute. Monkey butt is like, feed me now. I hear you, boo. I hear you, boo. One of these days I will get monkey butt out for y'all. One of these days. But my son has to be home. Because doing this and handling her is a lot. Okay, here is a case overview for Corey Richins. Let me get it where I want it. The defendant is Corey Richins, Utah real estate agent and mother of 3. Victim Eric Richins, the husband, successful masonry and stone contract, marries him. The court allegations are that Corey is accused of poisoning Eric with a massive dose of illicit fentanyl in March of 22 and later publishing a children's book about grief, about sudden loss, while allegedly hiding her involvement. The aggravated redrum and multiple counts related to the I can't do it. My apologies, y'all. Now she's quiet. She's like, mommy. Well, it's my fault. I bolted in here and didn't give her time this morning. So anyway, back to us. The charges are aggravated red and multiple counts related to alleged poisoning and distribution of controlled substance, i.e. fentanyl, plus financial crimes in some filings. Good morning. Let me say hello to everybody in chat. Miss June is in the house. Ari, how you doing? No, it was 10:30 a.m. That's what happens when you do things. But you're here. No, she actually was fed by my son. So I, and honestly, she's not hungry. She wants attention, and I'll give it to her in a minute. The status as of late the 2024, she's in custody, considered dangerous flight risk in court. With her case in pretrial phase, the active litigation over evidence, finances, and statements. Allergies. That reminds me. The key players and relationships and what really went down in this case. And I got to keep my eye on the video and make sure they haven't gone live yet. Refresh. Nope. We're waiting. Okay. They're waiting. Corey Richins is the defendant. She was a real estate agent and mogul. Did I move it? I sure did. Oh, well, do it later. She's an interesting little kook. Let me just say that. She presents herself publicly as a grieving widow. Author, she wrote a book to help children. All of that. I almost want to call her a black widow, but she was motivated by finances, which is what happens in most of these cases. They are financially motivated and deeply in debt. She stood to gain the death, life insurance for Eric's death, control of all the assets, and the house and the car and all that. So she would have become very financially independent. Eric Richins was decedent, contract business owner, primary earner. So he worked mostly. Most of the money came from him. He suspected Corey of trying to poison him before telling his family and friends about the drink or dinner that was made for him, that made him extremely ill prior to a trip. He allegedly took steps to change his life insurance and estate planning to protect his assets and children if something should happen. The alleged fentanyl deal, the housekeeper, a woman who says Corey asked her for prescription pain pills and later specifically some of the Michael Jackson stuff. So she knew what to ask for. She did. She asked for the Michael Jackson stuff. Boo, that's a problem. Fentanyl is commonly understood as a reference. The Michael Jackson stuff, i.e. the fentanyl, is commonly understood as a reference to powerful medications used in high-profile deaths. Yep, it is. It's horrible stuff. I take it back. If used appropriately, fentanyl can be fabulous stuff. As with anything, used appropriately can be wonderful. So why would you go as far as to, well, how do I put this? You're pure evil witch. Let's just say that. Allegedly, the woman supplied Corey with the fentanyl on multiple occasions. A key witness for the prosecution tying her to the actual physical means of unaliving. So this witness is key. I hope they have her under protection because this woman sounds like somebody who would awful witness. I'm not kidding. That's how I feel. The background and tension before 2022 was immense. I'm trying to save something in. There we go. It's starting to save. Now, there were multiple strains in this relationship, as with any, but the main strains were marital strains. I told you allergies are going to kick my butt today. Allergies are going. Maybe that's why I slept so well. I took some meds last night. Account from a friend states that the family suggests financial conflict, dispute over property deals, and tension about money and the control of the money. Life insurance motives is definitely on the table. Eric reportedly changed benefits and structured his life insurance and estate because he was worried about Corey was getting everything out right. There's also suspicion of previous poisoning on a trip, often reported as to Greece or Mexico, depending on the source. Eric allegedly got violently ill after drinking some of Corey Richins handed him. Afterwards, he expressed fear that Corey had tried to unalive him and told family and friends he suspected an attempt on his life. Well, if you're suspecting attempt on your life, why are you still in the same home with her? And why would you sit there and take anything from the woman? In my humblest of opinions, why would you? Yeah, I'm not blaming him by any means, but if you suspect, it's not what I did. I'm having a problem saving something. Let's see if it worked. I don't think it did. Yeah, it did. Yay. Okay, let me get this fixed. There we go. Yay, it worked. Trying some new stuff. New year, new things. So anyway, also there's more financial mover and happenings going on. There are allegation of forged documents related to life insurance and financial accounts. The state frames as a pattern of Corey attempting to poison herself to collect substantial money if Eric dies. Okay, so not only did she poison him, but she was trying to poison herself, I guess enough to make it look like it was her ex, but not enough to kill herself. Wow. How interesting is that, y'all? Good morning. We got other news hitting in a minute. We've got some stuff that my mods have given me this morning about some other people. So we'll be going through that in just a minute. Let me get this back up. Sorry. All right. Corey and Eric reportedly celebrated a business deal or a closing of the house. Corey allegedly fixes Eric a Moscow Mule, a similar mixed drink, in their bedroom. She claims she then goes to sleep in one of the children's rooms because children had a nightmare. Early in the next morning, Corey calls 911, reported Eric as unresponsive. First responders find Eric deceased in the bedroom floor or on the bed. That's not clear yet either. Initial suspicion is a possible medical event pending a toxicology. However, after toxicology, in autopsy, the medical examiner finds extremely high levels of illicit fentanyl in Eric's system, describes it in affects of 5 times the legal dose. The fentanyl characterizes as illicit non-pharmaceutical, aligned with the street drug rather than the prescribed medicine. There are 2 forms. Phone and digital data investigative reports state that deleted text messages and activity on Corey's phone around the time of death, search and pattern consistent with someone trying to obtain and understand strong opioids such as fentanyl, communications with the alleged dealer leading up to the shortly before Eric's death. The dealer's statements, alleged supplier tells police that Corey asked for something stronger and specifically referenced the high profile overdose death. She claims that she sold Corey fentanyl laced pills days before Eric's death. I'm sorry, if you're going to a drug dealer for that kind of stuff, that dealer knows you're about ready to do something bad. Now, here's the twist. The grief-stricken book, children's book. After Eric died, Corey authored a children's picture book about grief aimed to help kids cope with the death of a loved one, i.e. her children and the death of their father. She appears on local media, framing herself as a widow, trying to help her 3 boys process their father's sudden death. The state's framing of this is that prosecutors will argue the book and media appearances are evidence of calculated image management, not genuine grief. They will highlight the contrast between her public portrayal and the alleged private reality, drugs, financial plotting, and prior poisoning attempts. So, the motive, financial gain and control over property and kids' money. The means was fentanyl supplied, and the delivery was through a drink cocktail called a Moscow Mule. The opportunity and behavior accessed that night and the post-death actions all create the prosecution's case. Now, the defense's strategy and arguments are that Eric's drug use or alternative source. They're going to suggest that possibly Eric might have been obtaining and using drugs on his own, other than someone else could have supplied them. They push back against the idea that Corey is the only possible source, attacking the dealer's credibility. They paint the housekeeper as unreliable, criminally involved herself, and potentially motive to shift the blame to Corey, i.e. the maid did it. They challenge whether the quantities and timeline align sales as much as medical findings. Reasonable doubt about the timeline. Questions about the exact time of death, how long fentanyl will take to unalive, and when it had been administered. They argue that Corey slept with the children. Evidence wasn't hovering over Eric, and not that she was, staging the scene at all. Spin on the finances. They can argue a lot of couples have complex financial, life insurance, and disputes, along with marriage, and that this does not prove redrum. Now, the media and public narrative, they highlight how another author of grief book who killed her husband. No, the narrative is sensationalized and potentially prejudiced, pushing for a careful jury selection and limits on certain evidence, i.e. or media material. The prosecution, they are expected to fight all of these zones in court. They, hold on. Do I have any mods in chat? Did I lose my mods? Detention or the bail. The court has considered her danger and a flight risk, keeping her custody. The state points to the calculation nature of the alleged crime, the admissibility of prior allegations of poisoning events, and Rule 404 styled issue. They can, i.e., the state, bring in Eric's prior illnesses and statements like, I think she tried to poison me. Yes, it is hearsay, but he's deceased. Prosecution shows pattern and motive. Defense prejudicial hearsay and not directly proven. So that is where we are with this. Today's hearing, which should have already started, everybody is waiting. I'm just double checked it. It is maybe they're doing it. Maybe it is a 30-minute delay. Give me a second. Okay. Okay, we should. Hold on. Would help if I could spell. Okay, so today's hearing, the court is going to spend today reviewing motions about what evidence will be allowed, challenges to the witnesses' testimony, arguments over prior allegation of poisoning incidents, financial motive evidence disputes, digital evidence and phone data admissibility, statements Eric made before death hearsay, and 404. Rule 404, and defense objects to the drug dealer witnesses' testimonies. So that is what we're going to be facing today. And while we're waiting on that, we've got some videos to play. So I need to get these things geared up. I'm going to do this one first. The Uvalde officers is not cooperating. Okay, let me scroll this back and get this queued because this is interesting. Now, this is yesterday's case for the former UISD Uvalde CISD police officer. Defense team speaks after the trial day one. Fortunately, I thought that layout had stuck. Unfortunately, the trial hit a little twist for the defense, a prosecution, but not the defense. In fact, the defense is seeking possible. They've been asked, "What do you want?" Evidence has come into court that was not given to them prior to trial, and that's what it was. And they are seeking remedy. What that remedy will be, we do not know. It could be a total mistrial, and yes, some of the lawyers have. Other content creators and lawyers have talked about this, and they said it is very possible that this trial may not even go any further. Let's watch what they have to say.
Listen, what do you guys have to say?
Well, I mean, obviously, we're surprised. That's nothing that we could have anticipated. I mean, the judge is being free to the right thing. He's given us time to present our arguments and emotion. He's going to review the notes that you guys heard and saw, and then we'll make our arguments. We have decisions to make. Our client has a decision to make, and then he'll make his ruling after we hear arguments from both sides.
Jason, how surprised were you at the difference in the statement?
Well, I mean, obviously, it's happening to us in real time as the witnesses on the stand. So I don't know. You probably could see that after she started testifying, I started looking back at the paralegal, and it just started going back and forth. And talking to Nico, because we had never seen anything like that before in anything we've had. Obviously, we've been going over this case for almost 2 years, and so yeah, it was surprising. And so then I said, well, let's question her and see. And then of course, she said, well, yeah, I've been telling them. And then the prosecutor says, oh yeah, she's been telling us. That's having an issue, obviously, because the law of Texas is that they're just telling them that. They just tell us.
Tell us what the issue is with the statements, whatever the difference is.
Well, I think we kind of went over it, but there are some inconsistent statements that she has that meet this habit. But primarily, the witness testified that she saw the shooter and saw a person matching the description of the shooter on the south side of the building, which is where we put an OD say we to talk about, or where we all agree that Adrian drove to when he thought that he was encountering the shooter or somebody with the shooter. He drove there, and that's what happened in open safety. But having this witness who has never said that before to us and only to them, that's what was shocking to us, and that does affect our trial.
Yeah, so it's a surprise. So she testifies for the first time. It's the first time we heard it. The part that was bothering to us, troubling, I think, to most people that were watching, is that she said this in the salad rack. To hear it for the first time in trial was nothing that we've seen before in discovery. That she has said this before. That's trial preparation, and it's a critical issue in the case. Location is a critical issue in the case, and what you're letting our Adrian saw or didn't see. But then the problem that's more troubling is the fact that she told them in December and they didn't know it.
Do you think this makes? Do you think this is the Brady standard, and you can?
And look, the analysis needs to be made. It falls under that umbrella, and so that's what's going to be argued tomorrow. And
it's because the belief is that this could potentially clear your client. This color.
Well, it's not about that. If any evidence that bolsters the government's witness or could contradict their credibility, even is relevant for us.
And so I wasn't here in the beginning. So are you going to ask her in this trial?
We're can't disclose that right now. We have to.
Is that something I would consider?
It's a remedy allowed by law, and we're not saying that we're going to take that remedy or not, or argue for that remedy or not yet.
But it is something that's possible.
The judge had that available to him.
Could you explain what the Brady violation is for people that don't know and why this might fit under Brady?
Well, it's exculpatory. So Brady covers exculpatory evidence, not just evidence that exonerates somebody, but could impeach a government witness to hurt their credibility. And in a case where credibility is really critical and it affects.
Okay, so the issue is her credibility here as well.
For this witness.
And they've also done Michael Morton back here in Texas too, but this train in as well.
Yes. So 3914, which is also the Michael Morton Act, Article 3914 of the Texas Code of Criminal Procedure says that the prosecution has to turn over everything that they have, including any statement that might be inconsistent with what a witness has said before. Obviously, what we showed is when the Rangers interviewed this witness 4 days after this happened, she never said that. And that's a pretty big deal if you saw somebody with a gun at your school matching that description. So when they said that, that's what we were arguing. And when she testified to that, I didn't know at the time that she had told the prosecution that, and they hadn't told us. And so I didn't know if this was something she's saying for the first time on the stand, or something she said to them before, when everybody clarified and agreed and admitted on the record that it was something that they had known and not told us. That's where we have this.
Mr. Lohead, just as a defense lawyer, as an attorney, Reiner can say, what fruits? I mean, to me, you seem really very concerned just from the professional.
Well, we only get one shot at this. I mean, this is not a game to us. I mean, Adrian's family and the families of Uvalde, they want closure too, and they deserve to know all the truth. This is not just about Adrian, it's about everybody, it's about that community. That's what it matters. I mean, this is a big deal. And so, if we're going to go back and we're going to strategize and talk and prepare the information the judge requested from us, and we'll make our arguments tomorrow, and the judge will make his ruling.
But certainly for the families, they've been devastated.
We're not contesting that. I think you saw that.
Yeah, but and then to have something like this today, imagine.
But Nico, could you talk about the preparation that seems to have taken place for this case? This is a huge case. This is a big mistake.
Yeah, Miss, we don't know what it is yet. Okay, but the judge will make that determination. What I'm saying, it shouldn't happen. Let's put it that way. And yes, the government is prepared. We have put a lot of preparation in. Families have been waiting. Adrian has been waiting, and everyone's life is to unfold. And so it's a big deal. I mean, if you're up there,
What decisions does he have to make tonight? What decisions does your client have to make tonight?
you have to make a decision. What remedy we ask for, and the judge has a lot of latitude of what he can do.
When you're here at the prosecutor say, I was running my own law firm. I was working with I just slipped my mind. What did you think about that?
And we were surprised. The score.
Nico, this is a first of its kind trial. You said this is the first time this has ever happened to you in your law experience. how do you go about just even figuring out what your next step is? Because this is something that everybody seemed to be caught completely off guard.
We have to make decisions that are in the best interest of our client. We have to do it legally and ethically, and that's what we're going to do tonight. We have to weigh out our options. We have to present them to our client. We have to talk as a team, theory ourselves, or fair legal. We're going to make a decision. I'm going to pray about it, and then we'll make a decision tomorrow, and we'll make arguments to the judge.
Just legally, what are the other remedies? Just
The judge can admonish them to excluding evidence, to be creative with a remedy, to in this trial. There's a lot. The law gives them a lot of latitude.
so ultimately it also
That's all. So we have to make a request first, and then the judge will make a decision on the request.
What's the significance
Thank you,
of
ma'am.
this? Because this is a very unique trial already. So the significance of this issue, of this kind of issue, especially in trials.
What the issue affects this case, and it affects the credibility of a witness potentially, and then you don't get a second chance and says we can't rewind. So either we ask for an extreme remedy, the judge either grants or doesn't, or we don't, and then we don't know what the result's going to be. So it's a big deal. We have to make the right decision.
Do you think we could figure out an answer tomorrow?
We as in her.
As in the judge, the prosecution.
Well, we'll make our arguments, and the judge will decide when and what he'll decide. He's not going to say wasting your time. He's an experienced jurist. Thanks, guys.
Thank you.
Thank you. I have spoken.
You live again?
I'm watching this for a second.
Most horrific. All of us feel for them, and this has changed our lives. I've been through a lot personally and professionally, and I've seen a lot of things, and I feel for them.
So in a nutshell, we kind of arrived late. What happened? What actually happened?
We have a witness that testified something different for the first time on the stand today, and actually disclosed that to the government in December. Nothing that she had interviewed before, inconsistent with what she had interviewed before, and so that was new. We're arguing it's Brady material, it's exculpatory evidence, and so we have to decide what remedy we're going to ask from the judge.
And you said you've never had a Brady case in all your time as a lawyer, correct?
A Brady violation.
Brady violation that you
Well,
guys.
we've seen a lot of them, but not to this not this is the big situation. So it was a surprise to see this.
What material difference did this indiscrepancy make to the case?
Well, the placement of the shooter is a big deal. It's a huge issue in this case, and so this witness testified very differently than what she interviewed in the past, and she disclosed this new information to the government in December of last year.
How does that?
They didn't disclose us.
And then how did that affect your side?
Well, I'm not going to tell you our trial strategy. I'm just saying that the issue is where this shooter allegedly was and what our client allegedly saw. And when he saw this, if he did see it at all, it is a big deal. It's an issue of the case.
And like you said, because this is a first of its trial case, you guys want to take the time to think about this.
Well, yes, we have to make the right decision and give the right advice to our clients. Absolutely.
Before this happened, you warned the jury this is going to be a very emotional couple of weeks. What did you see in their faces? Could you glean any kind of reaction to what each side was telling them today?
I'm not going to comment on what I saw and didn't see from the jury. I just know what this case entails, and I've seen all the evidence. Emotional case. All right, guys.
Thank you. I appreciate
Thank you
it.
very much.
Thank you, sir.
Okay, guys. So, like we discussed earlier, it is definitely a huge deal. We are also waiting for the Nick Reiner court to pop in. We've got two things we're waiting on. We are waiting for the Corey Richins and the Reiner. Why do I keep calling it Nick? It is Nick. I want to call it Kirk for some reason. Reiner trial. So that is basically what's going on. Is we are waiting both of these. We do have another video I want to show you. Let's see if the court TV video will play. Here's the sound. Okay, apparently my computer has lost connection somehow with the feed audios. Give me a split second. I will leave screen and then I'm going to pack back in. Don't worry. I am still here. I just got to reboot that thing. So while we're rebooting that wonderful thing. Take a look at these two lovelies. We're back. Okay. Allergies, I'm doing the best I can. I may have to take another med, but it makes me sleepy. Try not to do that. Okay. This is Rosa reportedly searched how to stab and kill hours before the attack. Police have not identified the motive. He is in court. He's the one that was attacked his sleeping mother. And I think he's the one that had the mother had the baby, 14-day-old baby, if I remember correctly. And he is hearing the 911 call, I think, at this point. This sounds bad. I'm sorry.
What type of games do you do? Mostly fighting or shooting games. I thought some ordinary, yeah.
Very good for the defense.
Also, the hearing was scheduled, I think, at 1:30 Central Standard Time. This case is the Uvalde case is in my time zone. It's only about an hour, 20 minutes ride from me. So there you go. Thank you, Spinsteer, for joining us. We are doing multiple hearings today. Yeah, we is. We's doing multiple hearings today. And let me get my stuff up and running. All right. Here we go.
And Alexander Ramos for the defense.
All right. Counsel, as I understand it, we're here today to address the defendant's motions to exclude 3 of the state's experts. Is that correct, Ms. Lewis?
Yes, Your Honor.
The states recently filed a motion to exclude one of the defendant's experts not on the list for today. We'll address that in some fashion in the future. Yes?
Yes.
Okay. Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
It's a preliminary matter. My apologies.
Just thank you, Your Honor.
Of course.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear. In its briefing, the state raised 2 additional arguments that the state asks the court to address. The first is that the defendant caused Eric Richins' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's...
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic. Thank you.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richins' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these 2 arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, the state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear. I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient persuasive basis that the arguments you just described satisfy the legal standard for intrinsic,
Sure.
or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that. And I don't think that comes through in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain. And the court, may have built in its thinking as to the other two of the state's arguments, but I don't know that that is reflected in the ruling, and I think it would help if it was.
Okay, I understand your position.
Okay, thank you, sir.
Anything else on a preliminary basis?
No, Your Honor.
Okay, very good. Ms. Lewis, my apologies. No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you. Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. Happy to have some legal argument and colloquy before or after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Amon and Dr. Fox first. I think that if Ms. Amon were to testify and then Dr. Fox, and then we could handle that. And then Kathy, you're doing
The other two.
and then Ms. Nestor's doing the other two. So I don't know if you prefer an order on those. So either order on the others.
And forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702.
So let's talk about that structurally. Okay. If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Amon first.
May I just briefly address the court?
Sure.
Then Ms. Sherbernack will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the
Cheap cheaters. They ain't the real deal. They only help me close up.
papers sufficiently address
But
the
thank you.
threshold, showing. As the court is well aware, after Ramosh, after cases like Clopton
Gun Hill Dairy, and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through. It sort of flipped it upside down, so it catches almost anything. And even if there's two witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other two are on the line. So if the court wishes to proceed on to specific questions about Ms. Ammon, then Ms. Sherbanek can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. So whose witness is Ms. Ammon? Ms. Sherman, I can ask you some questions.
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Ammon's testimony, on 2 occasions and in bold print, the state says Ms. Ammon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Ammon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Ammon's testimony may be helpful to the trier of fact to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence. But this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part.
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Ammon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Ammon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Ammon will not be saying Ms. Richins fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Ammon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
Sometimes, right?
well, yes, but also Ms. Ammon could describe that in every targeted act of violence, and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline in the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack.
A legend.
All of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in
Sure.
defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean, and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist. And Ms. Amon would not know who those people are.
I read her proper. She seems to explicitly acknowledge that people stop at various points
Right.
along the pathway.
That's my point. So
Okay.
to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always. No, that's not her testimony, and that's not factual. But for her to say, in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sugar?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point and
Is it cited in your brief?
no, because I didn't know about it.
Okay,
It's
can
something
you
I
give it to me?
just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F3rd 900. And that case was also a blind expert who is actually one of Miss Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument because the way this works in courts when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. Has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Ammon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here, but there's a higher level to it. And when we look at Diaz is even more specific, and somehow the majority of the United States Supreme Court is like, yeah, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Amon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know it is, and I did not reread that case. So I would actually
we can we'll take a break at some point.
need a moment to review that to be right.
Okay, Ms. Sherbanek.
Oh, I'm sorry.
Oh, okay.
I do think that it would be helpful to hear Dr. Fox's testimony. For one thing, this routinely isn't used. It's used at NBAU as an investigative technique sometimes, but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not used in the community. And I think that does stop it even under our low threshold here.
Well, hold on, but come back to the specific context of this case. The state has noticed Ms. Amon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Corey Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Amon.
I think we're going to need some clarification beforehand. If Ms. Richins testifies and testifies that she did not do this,
that denies committing the crime,
then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem, no matter how. And this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to.
go through and explain the problems with the reliability of the science, and then go from there, if that's all right.
Sure. Ms. Sherman.
The only points I wanted to make, and the court has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Miss Amon's proffer does not fit within that. There are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Miss Amon's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, yeah, but I don't need her to address the law at all. I just need her to tell me her view.
I understand, but she hasn't now analyzed it under the Utah law. All right. Would it be all right if we go forward with Dr. Fox?
Sure. Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So could you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you, did you want to swear her in? We didn't do that.
Yes, thank you.
Thank you.
Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tax. I went to the University of Florida to earn my master's, and then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with red assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Amon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division. And in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly. You talked about that you worked with the BSU, and I know Ms. Amon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over the research on. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
All right. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment in my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then tried to help improve the scientific validity of both profiling and threat indicators, is what really motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessments, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay. Just wanted to make sure as we move forward. All right. So are you familiar with the path?
We're not arguing that she's not an expert. We accept her as an expert. That's not the argument. Let's continue.
Pathway to violence model.
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. It applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. It applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just like by thinking about what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, that's one person's opinion. There hasn't been a scientific evaluation of this to actually say, this often it applies, this often it doesn't. There's no known error rate. There's no accuracy rate. There's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the pathway to violence is descriptive framework and not predictive.
Yeah, it's descriptive. It would be like saying that both of us are female, and females are more prone.
You guys, as much as I am really digging this, we got some breaking news in the Nick Reiner trial. So we're going to hop over there. This is a hearing, so we can hop back in. Yo. Yeah. I guess what I could do, what I should do.
Breaking news.
Yes, breaking news. Alan Jackson withdraws as attorney. Alan Jackson withdrawing as attorney for the Reiner case. Here we go.
And the family apparently is going to be releasing a statement in terms of why, after this proceeding is over, still going on there at the courthouse in downtown LA.
Still with us, Marie Pereira, criminal defense attorney. Marie, just taking a look at just some of the things that are online about this. This is breaking news. And so Alan Jackson had come out and he was going to be representing Nick. We were expecting Nick Reiner to enter a plea today, but now we're hearing this is, a major change in the case.
I'm not surprised, because when you hire someone, they go to court, you file a notice of appearance. That notice says that person's going to be your attorney. Now, if the person had a retainer agreement and you can't pay up, nobody works for free. He has the right to go to court and be officially withdrawn from the case. I'm surprised that it's
Okay, Alan Jackson did not get paid the 5-10 million per trial with Karen Reed, but he's getting money elsewhere. He's getting it on the back end from other ways, but he ain't gonna do every case for free. And I think that we were all wondering, how is Reiner paying for Jackson? And I guess Jackson wanted him to take a plea deal, and he said no. And he says, I'm done, maybe. I don't know. They may not agree with his strategy, right, Ariel? Either that, or they don't have they could not liquefy assets they thought they could. Sometimes you hire an attorney, you got all these assets, but guess what? The case is so damaging to you that their assets dropped in value, i.e. property.
It was that easy, because in my world, as a defense attorney, once you do the notice of appearance, you say, this is my client. So for them to just allow him to just get off the case like that without providing the court with an explanation is surprising to me. Because in any normal situation, once you file a notice of appearance and you put your name on that defendant's name with the docket number, you really have to have a reason on the record, not just I'm withdrawing from the case. Yeah, it has to be more than that.
Presumably that's what's going on right now. We're at a disadvantage. We're getting tidbits from TMZ, which it's frankly very reliable in terms of courts, and especially Los Angeles. They have that lockdown, but we don't know everything yet. We'll find out soon enough. Let's talk about the case in general. He murdered his parents. I mean, it's very evident. The evidence is there. No one is saying that he didn't, right? You know, even from the very beginning here, even Alan Jackson was we're talking more generically about what's next. And so what is next? What should happen to Nick Reiner? I mean, if he wasn't Nick Reiner, if he was Nick Ferguson from LA, whose parents were no names, he'd be sitting in the Twin Towers, but he'd be on his way to either San Quentin or, you know, Mule Creek.
Well, whoever he is and whatever his last name is, he still has the presumption of innocence. So he's innocent until proven guilty with very little reasonable doubt, right? That hasn't happened yet. So I want to say, when you say, you know, he murdered his parents, we're assuming he murdered his parents, but there's still
only because of the amount of seeming evidence. Of course, he's innocent until proven guilty.
Yes.
But Nick Reiner murdered his parents. Let's be honest. You know.
There still could be a defense, though, because sometimes there are homicides that are justified. We don't know enough about the case. We're going according to what we hear. We don't know the exact results from the autopsies. We hear there were throats slashed. We hear people were stabbed in bed. We hear that there wasn't like a fight. It seemed more like an execution. That's what we're hearing. But until the case goes to trial and all of the evidence is released through discovery between defense and prosecution, we don't know. We don't know if there is a defense of he didn't understand what he was doing, that he's maybe not guilty by reason of insanity. He didn't have the ability to form judgment between right and wrong at the time. Maybe he was so high on drugs that he was impaired, because it's on record that he struggled with substance abuse. Not to say that in and of itself it would get him off the hook, but there are lesser charges when you do it and you don't know what you're doing, or you were impaired by drugs. Nothing has played out yet. So whether or not he's Nick Reiner or Nick Jones, he still enjoys the presumption of innocence, and they still have to prove their case against him, all of the elements beyond a reasonable doubt.
And we keep getting more and more updates. So really what now TMZ is saying, their sources are saying that a public defender is going to step in.
Okay.
For now, the case is going to be continued. Nick will not enter a plea. We were thinking that that was going to take place today. So also we're getting an update from the Associated Press. Nick Reiner appeared behind glass in a custody area of a Los Angeles courtroom. He was, you know, wearing his jail garb and had his hair shaved. So this is according to people that were inside or watching this from Los Angeles. So the attorneys went into the judge's chambers to confer before his case ended up being called. So just getting some more updates on it from right now, Marie. So just a surprise, because I believe, you know, we have some sound from when Alan Jackson came out and was going to represent Nick. I think we have that queued up. Why don't we go ahead and play that? We can talk about that on the other side.
I just have a couple of quick words. First of all, and most importantly, this is a devastating tragedy that has befallen the Reiner family. We all recognize that. Our hearts go out to the entire Reiner family. There are very, very complex and serious issues that are associated with this case. These need to be thoroughly and very carefully dealt with and examined and looked at and analyzed. We ask that during this process you allow the system to move forward in the way that it was designed to move forward, not with a rush to judgment, not with jumping to conclusions, but with restraint and with dignity and with the respect that this system and this process deserves and that the family deserves. So with that, we are set for January 7th for an arraignment. That's the next court date. And that's all I have to say at this point. There may be more at some other point, but today we're going to rest on where we stand procedurally, which is this was the continuance of arraignment. Nothing happened today substantively. We'll be back for arraignment in the same department on the 7th of January. We'll see you then.
Yeah, so Marie, we heard Alan Jackson there talking about this, talking about it being a complex case. He was saying a lot of parts to this.
like I was saying, it could be not guilty by reason of insanity. And I know it sounds crazy. It could be self-defense because we do not know what happened inside there. And we can't go according to everything we hear from TMZ. We have to give the man an opportunity to lodge a defense. But you see how gung-ho he was, and now you're saying the case is probably going to a public defender. I want to tell the people, just because it's a public defender doesn't mean that it's not top-tier representation. Because remember, Philip Dubé used to be a public defender. I
In
think
that
Philip needs to come out of retirement and deal with this case. Because
in that office. He
Yeah.
is the walking encyclopedia. He is our version of AI.
Most of the great defense attorneys come from the PD background or a prosecutorial background, and you know, you get that training every single day in court. You have cases every single day, and so you know, PDs definitely can be amazing. So, Marie, thanks. We're going to squeeze in a break. We're going to have more of this breaking news out of Los Angeles. Alan Jackson withdrawing from the Nick Reiner case. We'll be right back.
And we're going to zoom. What are your thoughts on this, y'all?
Starts coming
What?
out about the son. Then you fast forward, then we hear that Alan Jackson is going to represent him, which of course all of our viewers are very familiar with Alan Jackson because we just came off of the Karen Reed case not too long ago where he had that successful victory with Karen Reed. But now the breaking news, he has withdrawn from this case. And we're hearing from TMZ that in a little bit we will hear the family is going to be issuing a statement, the Reiner family, as to a reason as to why this departure is taking place.
And the judge in this case.
Because we don't like him. I don't know, y'all. I just need. This girl cannot get comfortable today, y'all. Maybe I ought to go put on leggings and get off these blue jeans. Can't get comfortable, y'all. Okay, here we go. Back to court.
Is not allowing live streaming. So there was, according to people in the courtroom, the Associated Press and others had representatives there. They went back into chambers before the hearing got underway. However, Nick Reiner is not expected to enter a plea today. And in the absence of Alan Jackson, it is our understanding from reporting, including TMZ, that a public defender will take over this case. And again, to your point, we'll learn more very soon because when this concludes, A, we'll get the feed, whatever did happen in open court, and then B, we're expecting that family statement with more clarity as to the reasons why Alan Jackson is off the case.
Yeah, we do have a background package on this, a background story, just kind of getting people up to speed as to the situation, as to what had transpired before. Why don't we go ahead and play that, and we'll talk about it on the other side.
Sunday, December 14th, around 3:30 p.m., Los Angeles firefighters responded to a 911 call at the Brentwood home of Hollywood filmmaker Rob Reiner and his wife, Michelle.
Upon arrival, they determined that there were two deceased individuals inside of the residence.
Rob Reiner, the son of comedy legend Carl Reiner, catapulted to fame in the 1970s as Michael Stivic, Archie Bunker's hippie son-in-law on the hit television series All in the Family.
All right, put it in.
He went on to become a prolific director of such films as This Is Spinal Tap, Stand By Me, and When Harry Met Sally.
I came here tonight because when you realize you want to spend the rest of your life with somebody, you want the rest of your life to start as soon as possible.
Reiner and his wife, Hollywood producer Michelle Singer Reiner, were found in their home fatally stabbed. The Reiner family confirmed the deaths in a statement posted on Variety.com. It is with profound sorrow that we announce the tragic passing of Michelle and Rob Reiner. We are heartbroken by this sudden loss, and we ask for privacy during this unbelievably difficult time. The Reiners married in 1989 and had 3 children together, sons Jake, Nick, and daughter Romy. Nick Reiner has spoken openly through the years about his issues with drug addiction and homelessness. In 2016, he appeared in this clip, currently circulating on social media, with his father. It was a panel discussion promoting the movie Being Charlie, which was partially inspired by Rob Reiner's experiences parenting Nick.
The whole process for me, I can just speak for myself, it did make me understand him a lot more, and I think it made me a better father. Hopefully it did. If your kid is going through rough times, you know, the parent is, your main job is to keep your child safe.
As police, media, and onlookers converged on the home, sightings were reported of Reiner's friends and collaborators, Larry David and Billy Crystal. Tributes poured in from Hollywood and beyond. Carrie Elwes, who starred in Reiner's cult classic The Princess Bride, posted no words. Jerry O'Connell was one of the child actors featured in Stand By Me, and he tweeted, "Love you, Rob, sincerely." Former President Barack Obama wrote in part, "Beneath all of the stories he produced was a deep belief in the goodness of people and a lifelong commitment to putting that belief in action."
All right, Marie Pereira still with us. What does logistically happen here when you have an attorney withdraw, no arraignment today? They'll just set a new date for that and give the new attorney, whoever it is, time?
Yes, the attorney's going to have to meet him, interview him, see if he's okay with him being assigned as the attorney. Although for the most part, if you're indigent, and that's who the type of person that gets a free attorney, a public defender, is someone who has no money to pay. Because in America, if you're accused of something that has to do with your freedom, a criminal case, if you can't afford an attorney, one will be appointed to you. And you don't really have much say in who it is unless there's a big difference and meeting of the minds. You get the attorney that they appoint for you.
But the high-profile case, you can be assured it's going to be someone with experience. We're going to get a break. Marie, stand by. When we come back, more Nick Reiner, plus that Washington State trial. Busy Wednesday, Court TV.
All right. We are waiting for the family to make their entrance and share. June, I have a question. I do see your document that you just dropped. Why are all your documents now coming from this program that I have to log into to read? Even I don't understand. I can't download it unless I create an account. So what is this program? This is the first time I'm seeing, well, second time we've seen it. That's interesting. If I need to create an account, I will, but I don't like creating a bunch of accounts for document reads, but we will if we have to. We've got a new document that dropped for Corey Richins. I will read it as soon as it comes available, and I can get it downloaded in the meantime. Let's get back to this.
Let's bring in our guest for the hour and get some reaction. She is joining us now from New Jersey, Livingston, New Jersey, Krista Pettiford. Chris, what's your take on this high-profile case, obviously, high-profile lawyer now out, Alan Jackson withdrawing?
It's kind of surprising that he's withdrawing on such short notice, right when the arraignment is being scheduled. Obviously, you can assume that there may be some disagreements on how the case should be handled or how he should plea. Otherwise, I can't imagine a reason why on the date of arraignment he would withdraw as counsel.
Well, yeah, I mean, Crystal, that's a great point, because that's what we were expecting to take place today, him to enter some sort of plea. And so if there was going to be discussions as to a departure, discussions as to, and I'm speculating here that maybe there was some sort of financial agreement that now has fallen through the cracks, you would have thought that you would have heard that they would have made a decision about this prior to today. So, maybe it's more than that. Maybe it has nothing to do with finances. Again, we don't know. We will find out shortly. But yes, for it to happen today, on the day that we're supposed to be hearing how he is going to enter in regard to his plea, that was kind of a surprise.
Yes, definitely a surprise. On the eve of an arraignment, it can only be assumed that it probably could be financial, but I would think it's more so something to do with how they should proceed.
We've been talking about Philip Dubé sort of because he was the lead public defender in Los Angeles County for many years and has just retired from that position. He's, still a lawyer, still practicing, but now no longer part of the office. And he's in Mexico right now, and he just texted me, and he's chiming in, and he brings up the probate situation, saying that under California Probate Code 250, a beneficiary to a trust estate cannot inherit if they murder them. Basically, there's no money to pay for the counsel. That it may have something to do with that. Again,
Yep.
we'll find out. But if you're an heir, you can't murder the person that is going to be you're going to get money from, and then use that money to represent you at trial. So could it be about money, Crystal, at the end of the day?
I mean, that's always a possibility, but Mr. Jackson is a very experienced attorney. I'm sure he's fully aware that Nick Reiner would not have been able to reap the benefits or of any money willed to him or left to him and as a result of his parents' death. So I think that would have been something that would have been discussed prior to the date of arraignment.
Yeah, absolutely, Crystal. And we're going to stick with this story because we're hearing that we're going to get some more updates here momentarily, maybe a live feed from Los Angeles. And of course, as soon as we get that, we're going to bring that to our viewers. But yes, I mean, going back to just what we were talking about, when you hire an attorney, there's usually an agreement. This is how we're going to get paid. These are my fees. This is what, we're going to do going forward for our payments, the retainer. And so then, and we would know that. Alan Jackson would know that, just exactly what Philip Dubé was texting you about. So there should have been some sort of knowledge already behind them as to what the financial situation was. So that's what makes me think, Crystal, along the lines of what you're saying, that maybe there was some sort of different reason as to why exactly this took place. I know last hour when we had Marie Pereira on, I was talking maybe because of case management. She was saying no, that's probably not a possibility because he would have known when he took the case. So I don't know. I mean, again, we're just speculating here, but Crystal, any more thoughts as to that? I mean, what do you think about case management? Sometimes you take something on, then you start going into it and you're like, whoa, I have so much on my plate. He has that high profile case out in Los Angeles about that young man who was driving along Pacific Coast Highway. That one's a huge case. He just came off the Karen Reed case, and that victory there, obviously, that one's behind him now. But obviously, he's a very busy man.
Well, of course, but he's also very knowledgeable and he's able to manage his cases effectively. Otherwise, he wouldn't be so successful. So I wouldn't think it would be a case management issue. Again, completely assuming. I can only assume that maybe based on it being previously adjourned, there wasn't understanding that there may have been a guilty plea. And it would be more about sentencing. Maybe there was a shift in that, and therefore now the fees associated with someone entering an early plea are much different than the fees for a defendant planning to defend themselves from the allegations. So I can only assume that it has something to do with that, and maybe the trajectory of the defense has since changed.
Yeah, Crystal, and that's an excellent point because yes, if Alan Jackson is going to go and come up with a defense and use his skills as an attorney and talk about not guilty by reason of insanity, and then all of a sudden there is a shift where we're going to come today, we're going to just say guilty, we're not even going to proceed. Yeah, that would definitely be a difference in finances.
Yeah, if indeed, Nick Reiner himself didn't want to participate and go a certain way, that might have been part of it. Again, we'll get more from that family statement. We're also expecting the feed of what actually happened in court today in open court. They all went into chambers shortly after the case was called, but the judge in this case didn't allow us to live stream. So we're sort of waiting for that procedural event to take place where we'll be getting that feed along with everybody else at the same time. And as soon as we do, we'll pass that along. The Nick Reiner's arraignment is delayed until February.
Yeah, so that's new information. We just have heard now. We
from
thought
the Associated Press.
we thought it was going to be taking place today, that he was going to be entering a plea, and now we're hearing just some breaking news that now that has been delayed until February. Obviously, understandably, it was delayed as of today. We just hadn't had that date yet, so that's some breaking news. Now we'll have that, and we'll bring that to our viewers when it does happen, about a month from now.
Yeah. Again, we're waiting that feed from the court. And Crystal, procedurally, now you have according to multiple reports, including TMZ, the public defender's office representing Nick Reiner. Some people may think, oh gosh, public defender's office. There are extremely competent public defenders. And in Los Angeles, a city of that size, they are going to appoint someone with experience to handle the complexities of a high-profile trial. He's going to still get good representation, correct?
Absolutely. There are many public defenders that are top tier. They do this on a regular basis. They handle cases of comprehensive magnitudes all the time. Just because a person is a public defender, that doesn't make them any less qualified than a privately retained attorney.
No, absolutely not. I mean, I remember back when I was working just as a, assistant state's attorney back in Illinois. And when I was first starting, you're handed so many files and you have to go in every day and switch gears from this case to that case to that case. And public defenders have that same kind of background, same kind of training, and many of them go on to be very successful defense attorneys. But that's what we're hearing, that in the meantime, Nick Reiner is going to be appointed a public defender. If he then will end up getting private counsel. Crystal, kind of talk about that process. When someone is deemed indigent and you have to fill out, at least when I was practicing, they had to fill out the paperwork saying about what they have for their assets. And then the judge makes a decision as to if they are able to be appointed a public defender, or if then they have to go to the next step and hire private counsel. We'll kind of talk about that process. Right now, Nick is going with the PD, and then eventually maybe he will go back to having private counsel.
Would actually be surprised if he didn't go back to getting private counsel, but his process would be no different from anyone else. There would be there would be an analysis of his financial means and ability to pay a private attorney. If he falls within the required guidelines of a person who is eligible for a public defender, then he would get a public defender. And as you previously stated, they're gonna appoint a public defender that is very experienced in handling cases of this magnitude. It would be the same process for him that it would be for anyone else. There's, I don't believe he was working at the time based on everything that's been out in the media. So I don't see why he would not qualify for the assistance of a public defender.
Crystal, let's talk about the case against Nick Reiner. It seems to be substantial in terms of he is the one that took the lives of his parents. Was it strangely self-defense? Was he under the influence of something? Was he coherent? All of these questions we don't know. We don't know a lot, but we do know that he seems to be the person that took their lives. What possible defenses really are there moving forward in this case from what we know?
The primary defense, it seems, based on what's out there, is he's probably going to go with something related to his mental health. From what we understand, he's been struggling with some mental health issues. Maybe he's going to try to say he wasn't in his right state of mind at the time of the killings, and that it wasn't premeditated. Otherwise, I don't see what defense. I don't believe self-defense will ever come into the equation, because there's been nothing in the news that his parents were in any way violent toward him. Everything leads to the fact they've been loving and trying to guide him through his rehabilitation phases of his life. So I don't think self-defense will come into play. If anything, I think there will be some affirmative defense of his mental health and incapacity.
Yeah, I would think, yeah, that's probably true. I'd like to go ahead and play that when Alan Jackson took over this case, he came out there on the courthouse steps and he talked about the complexity of this case. He talked about it being complex. When you first hear about the case, you're like, oh, okay, You hear the parents were stabbed. Then you hear that the son is involved in some way. And then you have Alan Jackson coming out and talking about the case being complex. At first thought, Crystal, I'll bring you in instead of playing that sound. But at first thought, you think, well, how complex can it really be? The parents are dead now. They were stabbed to death, and it's coming out as information as to the son is responsible. But you'd hear a very seasoned defense attorney come out and say the case is quite complex. What are your thoughts on that?
I think when an attorney says the case isn't that complex, it's quite complex, my apologies. In a matter like this, I think it's to stop the public and potential jurors from rushing to judgment. If you make it simplistic, then we jump to the conclusion automatically that this was a person who was out of control and killed his parents. But when you want to make it a broader issue, possibly mental health or something else, then you want to keep an open mind and you want the jury to focus on the complexities and what led up to these specific events. If you make it any less complex, then the writing is on the wall that he killed his parents, and that's the end of it.
Good point. Good point. And again, that arraignment we were expecting to take place today now has been delayed until February. So a lot of moving parts here.
Yeah, and apparently the feed that is coming out of Los Angeles of the hearing that was on the record, there are some complications with that. So let's do this. Get a break. We'll regroup. Probably head back to Washington. Watch that.
Okay, so the hearing has been moved to February 23rd, which is a Monday. I'm assuming the same time. I'm going to keep it at the same time. I'm going to keep it at 8:30 just for now until we hear different. But that has been moved to February 23rd. Thank you so much, Angela, for that. Appreciate it.
Until we get more from the...
Okay, we're going to go back over to the Corey Richins. But before we do, we got more news and more documents. I can't share the document yet because I have to download it. But let me do I got to wait 10 more seconds, I think. Okay. In the Corey Richins trial, the defendant is seeking an order to dismiss all charges against her because she claims the state has engaged in prosecutorial misconduct such that fair trial in this case is no longer possible. Alternatively, the court should enter an order that 1, disqualifies the Summit County Attorney's Office, 2, changes venue from Summit County to Salt Lake County, and 3, suppresses all evidence related to the walk the dog letter, and 4, provides the jury with instructions to produce consideration of the state's false claim that Ms. Richardson had engaged in witness tampering. Prosecutorial and factual background for this case. Trying to embiggen, but I got ads popping in front, so give me a second. Okay. Yeah, I got to scroll back down. Here's the argument. Oh no, got to go up further, way further. This is a 52-page document, so we're going to look at a few things and then we're going to jump to the bottom. The procedural and factual background: on May 31 of 23, the state filed a motion for a gag order in which the court for the imposition of the gag order in response to the unanticipated overwhelming media interest in this case. Really? In this day and age? Come on now. Y'all, if I don't read it fast enough, it goes through an ad every so many seconds. All right, I'm going to show this so my mods know what the hell is going on. All right. Okay, so look, guys, I do this and I start reading and then it nabs me again. So let's see what I can do. Prosecution of factual misconduct. The state argues the request for relief was necessary to protect Ms. Richardson's right to a fair trial in a court of law, not the court of public opinion. That highlights the importance of avoiding pretrial tainting of the jury pool. The state also acknowledges circumstantial cases, particularly as to refers to the media coverage. Global media outlets dramatically increase the risk of tainting the jury pool. On June 2nd of 23, in response to the state's motion for a gag order, the court entered an order inter alia, I guess, requires compliance with the rule and you stated gag order. Among other things, the gag order prohibited lawyers in this case from making any extrajudicial statements that the lawyer knows or reasonably should know will be determined disseminated by the means of public communication and will have substantial likelihood of materially prejudicing and adjudicated proceedings in this matter. Sorry, it's small print. If I enlarge it, it doesn't. Let me see if I can enlarge it. There we go. September 15th, the state filed the document Walk the Dog letter, WTD letter, and the public docket in the case. The state did not file the WT letter pursuant to rule of civil procedure and the rule of criminal procedure. Along with the WTD letter, the state also filed police reports and public docket in the case. So they're filing the information. They have public and then they have sealed. They are being accused of putting information in the public document, and that's a no bueno. And see, there we go, guys. I gotta wait. So what I'm going to do, we're going to go back over here. I can't keep showing this. Just so they have filing a bunch of different motions. We will go through those as soon as I can get a clean copy.
Nick Reiner was to be arraigned today, and Alan Jackson, his attorney, high-profile attorney, has withdrawn from the case. That arraignment's been pushed till late February 23rd.
Yeah, and we're just getting some information now as to what the family is saying. They did issue a brief comment saying that they have the utmost trust in the legal process and will not comment further on matters relating to the legal proceedings. And they went on a source. This is a source told the New York Times. So this is according to the New York Times. The change had nothing to do with Alan's performance and that he had been a pro. So new information there. We had reported earlier that Alan Jackson has withdrawn from the case, and now we're hearing just some of this general information. Of course, they're saying nothing to do with Alan's performance and that he had been a pro.
And the public defender, Kimberly Green, 19 years of experience, apparently has been appointed to the case. So she'll be along his side when they are back in court at the 23rd. We are still expecting that feed from the courthouse. There's been some technical problems with that. So nobody has it yet. As soon as it is released, we'll pass it along to you. But the breaking news today, obviously, is that Nick Reiner not arraigned yet, and Alan Jackson is out.
Yeah. PD representative. We're going to switch gears. Go back to Washington State. This is for the cheating fire chief murder trial that's taking place out there. The defendant in.
Well, I think we have it. I think Long Crime has it. Just let me get it up. Let's see if this is it. Thought it might have been it.
On behalf of Mr. Reiner, counsel for 4 and 10, number 4 on
Okay, so it froze right there.
Calling People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court out of custody. I'm sorry, in custody.
Thank you.
Okay, this is the old one.
The beat bailing for the people. Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principled objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
I don't have a list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Counsel for 4 and 10 present.
Yes, Your Honor. I'm not sure which number I am.
Number 10.
I'm counsel for number 10, and we do object to issue if that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are here to issue a rule of body attachment.
And counsel for number 4.
In council number 10's statement, I don't see the necessity for issuing a body attachment. I too will stipulate the jurisdiction without necessarily waiving any objections we ultimately may make. But given my newness to the matter, I don't see the necessity of having a court order issued against an individual in this circumstance.
Thank you, Your Honor, and just to be clear, we do also reserve all of our objections.
Yes, and so, but as to the remaining numbers, that's 1, 2, 3, 5, 6, 7, and 8. Those the court will issue body attachment and hold it until the next court date.
And
9.
Thank you. We have no objection to counsel's representations, given the fact that both have graciously submitted to jurisdiction with regard to 4 and 10. We think that's appropriate.
Thank you. Once again, the court will issue and hold 3, 5, 6, 7, 8, and 9.
Thank you.
Until the next hearing date. And we'll
Does the
seal,
court have a list?
it does, and the court will seal that list as well.
We've asked
People have a copy or
We've asked that the court seal it specifically because it is ongoing defense investigator data or evidence that we recover or we get. Our counsel on behalf of Mr. Reiner gets, and that is discussed.
Okay, I think this was the first. Okay, we're going to go back to Corey Richins until we have more news. But they have filed a motion, several motions. So why don't we do this?
You know, I'm trying to even think of an example that would, you know, that would be kind of as like detached from the data. But you know, we could say, well, both these women would, you know, engage in, you know, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two, you know, people that, you know, are judges seeing today, both are in a courtroom, that doesn't mean all women are in a courtroom. You know, the example I use in my undergraduate course, every person who went to the moon eats chicken. That doesn't mean that everyone eats chicken goes to the moon.
All right. So does the pathway to violence, does it tell us how likely it is that someone will engage in violence?
No, that's a major flaw with it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I mean, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I mean, I can name like so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence, or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, you know, out of a larger group, and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the pathway to violence model is doing, this is, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I am aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You can write whatever you want as long as the publisher agrees to print it, you're good to go. In Ms. Amon's proffer, the pathway to violence model was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like I'm mean, but that's a predatory journal. They write to me often and ask me if they can publish whatever I want in that journal. It's not like a legitimate, valid journal. And that paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was only mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that, stamp of approval if it's not reliable and valid. That's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the pathway to violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody what I determine to be a grievance could be different than what Ms. Amon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say, that fits, and there's subjective interpretation and value behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely, because there is no standardized criteria for what these things mean. They're barely even defined because, again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these side areas. So an example of this would be 2 evaluators could use the pathway to violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is, if you have 2 people stand on 2 scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on 2 scales at my gym and at my doctor's office, and there's 2 different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day, and all of a sudden you're getting different results, it could mean that your weight has changed. But if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, inter-rater reliability is basically this idea that if two people use the same construct, will they get the same result? And if people are having the same scale, implementing it, and get different answers, it's not reliable. And it just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect. Integrated reliability, that's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the inter-rater reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right. Is there any scientific data showing how often? I'm almost done, but I'm sorry, what?
Oh, I didn't say anything. My apologies.
Oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and just without overemphasizing this, there is no
You to come pick 'em up.
data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on their pathway to violence. That was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I've been finding, I didn't have the resources to really complete this in the way it should have been done. And it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, I teach a forensic psychology course, and so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition.
Okay, guys, we're going to take a little break from this. I've been pulling my information, and I've created some notes. I want to talk to you a little bit about why this is important, what's going on. Some people struggle a little bit with following, and they're asking questions. So I'm here to answer your questions. So let me clear out. I've got a bunch of pages up and running. We'll go through that later. We'll do that later. We are waiting for the Uvalde case. Will go live at 1:30 my time, approximately 1 hour. So I'm just cleaning everything up so I'm a little bit more, I don't get so distracted with everything. Okay. So why is all this important? What is going on here? So let's talk about it. Then maybe we can follow a little better. Today they are talking about the 2-part evidentiary hearing. And in that, the judge will need to decide several things. So number one, the expert witness can testify. Which one actually can testify? What digital, financial, and relationship evidence is admissible in this case? How far the prosecution can go with motive and escalation of theory. The escalation of theory is going to be the issue here. This is very, very important for the trial that's going to happen in February. The hearing will shape the entire trial. If the judge allows the pathway violence expert, the prosecution gets a powerful narrative tool. If the judge excludes or limits this witness, the state loses major framing evidence. So pathway to violence is an expert. And what does that mean exactly? Even though the phrase standard forensic psychology concept is used in homicide, domestic violence, and targeted violent cases, what this expert typically covers is behavioral patterns and proceeds to intent of the violence. The escalation indicators, meaning, were they planning it? Is it a rehearsed? Did they practice it? How did they procure the tools needed to carry out this act? Stressors that indicate increased risk, such as financial collapse, relationship deterioration, health issues. What is it that caused this person to do what they did? Patterns seen in I can't say it. Inmate partner homicides. Okay. How certain behaviors fit known trajectories. So, meaning they have found over the years of studying criminals who've committed this type of crime or a specific crime, and they have planned it. They have thought about it. It's premeditated. It is orchestrated. There are some supposed telltale signs. What can they not say? They cannot say, for example, Corey Richardson is violent. They can't say, okay, they can't say she absolutely fits the profile of a red rummer. They cannot emphatically say that. They cannot diagnose her, and they cannot tell the jury which verdict to reach. The prosecutors want this. Why? Well, it ties everything together. It ties the financial motive, the medication or drug acquisition, the alleged prior poisoning attempts, the digital searches that she did, the relationship deterioration, and the post-incident behavior. Now, the defendant's fighting it because it sounds like profiling, and that is huge. That we've heard the judge say about profiling. You can't profile. And the district attorney, assistant district attorney, the one representing the DA's office, made a comment, and the judge says, she can't do this. This woman can't testify to that because that is perceived as profiling. Character evidence, and they can't, because it also sounds like she fits the mold testimony. That's prejudicial and overrides probative. That is what today's fight about. It's about scope and admissibility. Right now, in the Corey, I keep wanting to call it Karen, Corey Richard case, the court is hearing the arguments about whether behavioral expert can testify about what known and the pathway to violence. This isn't profiling. It is a forensic framework that looks at how people escalate towards serious harm. Prosecutors want to use this expert to explain the patterns they say appear in the evidence. Financial stressors, alleged prior poisoning attempts, the acquisition of the drugs, the deterioration of the relationships. We can go on and on. But the defense is really pushing back hard, arguing that this kind of testimony risks telling the jury that Corey fits the type, which is not allowed under the rule of evidence. The judge is spending today's time deciding how much, if any, of this expert witness will be allowed. Okay. So again, the pathway to violence is a forensic model describing how individuals escalate towards serious harm or identifiable stages. It is used to help jurors understand the pattern they wouldn't recognize on their own. So basically, it's almost like a behavioral analysis, but goes a lot deeper. The judge is very comfortable. By the way, it sounds like profiling, and the courts really restrict the profiling. So it's like you're teetering that line when using this. And the judge is going to monitor it with a fine-tooth comb. He's going to be looking for, number one, is it reliable? Is it relevant? And is it helpful or is it prejudicial? Can it be explained in any other way without implying guilt? Okay. That is what all this is about. I hope that has helped you understand what we're hearing in court. I hope. Let's continue.
Educated guesswork and hunches. And so I always teach my students, like, that was the 70s way, but we're doing this differently now. And the pathways to violence model was developed in that same approach. Educated guesses.
Okay. So Ms. Amon, and I guess suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the pathway of violence model?
No, I mean, that's like a basic logical fallacy. That was probably on your LSAT exam, you know, that you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually, there were, there's the pathways to radicalization. We've, toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile. And it was this like traits shared by attackers. They're young, male, Middle Eastern, and you could say, looking at, the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Like literally it goes down from, everybody who, commits terrorist attacks fit this profile to 0.00000, like I don't even know how many digits out, 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw by implying these group level descriptives. You're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. Go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, like as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, I mean, think about the problems we have when we're talking about parole. We're talking about, risk assessment, when we're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is. But because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing at how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually ever predict who will go forward to commit a violent act?
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, I mean, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict the violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than any type of long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
So snake oil, I mean, this, I don't think the judge is going to, if I heard that why do you have this expert coming forward? If it is fact, it's true that with all of the science that you have behind this theory, okay, the what is it? Pathway to violence theory that's there. You have all of that information and you still cannot identify things. I agree with this person. They're not able to do it. So why bring this expert witness in when in fact the science behind it is not valid? It's not good. It's not producing anything. It's not. What are your thoughts on this? Would love to hear from you guys. Do you believe? Oh, that reminds me. I do need to put a poll up. Thanks for the reminder. But what do y'all believe, mods, viewers? Do you think the pathway to violence expert should be permitted after what we just heard? What did we just hear? The factor that predictive validity, any type of, long-term grievance, at least based on research. If we were able to do this, I would feel better with her son Young. I'm reading some of the captioning. I'm terrified because we're so bad at it. Even from huge amounts of money being spent on this type of research, we still are unable to do it with any type of, reasonable accuracy, because finding that needle in a haystack, someone who meets all the criteria but is actually going to commit the violence, is hard to do. What are your thoughts on that? Y'all, that doesn't make me very comfortable, and it doesn't sound very competent.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no. And that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here. And that's absolutely not the case. A domestic violence type of scenario, poisoning, they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right. So just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid, it absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Shervnak, do you have any questions for Ms. Fox?
I do.
Ms. Fox, may I ask you just a couple of basic questions?
Surely.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization. And I just learned about that. And again, like while I was in the BSU, that was one of the things.
Okay, so he is asking very important questions because he's talking about upholding the standards, and the FBI and all of them have this, I don't think he's going to allow this. I'd be shocked.
Revamp and improve.
Okay, thank you. Ms. Lewis, anything further? Ms. Shervanek, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
That did not bode well.
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon? Is the state going to put Ms. Amon on, or only if I have questions? I guess would be
Ms. Shervanek, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from her.
Okay. Ms. Amon, do you mind turning on your video and audio? May I swear you in, please? Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Amon.
Good morning.
Your Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I prefer to focus my questions directly elsewhere. If that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases...
Why are we talking about cats? Cats are not humans. Cats don't act, behave, respond the same as humans. I don't like hearing studies when they talk about certain animal testing, because you know what? You can test them on animals when it comes to emotional response all you want, but they are not humans. How does cats equate to human, Redrum? Let's find out.
They demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, staying in an end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. Affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound, and the cats would inch forward, and they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat.
if you're going to compare any animal in the animal kingdom to humans, do so with using monkeys, because we are more close to them than any other creature in my limited knowledge. How are we close to a cat? I would put more weight in this if we were able to equate it to like a capuchin or an ape. I don't know about y'all. I'm sorry. I want your opinions. Do you agree with comparing a cat mentality to that of a human? And the cat's emotional state in a startled or fearful response to that of a human?
And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI, to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000-foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk.
Okay, so let's take this and put it in my practical term. Let's put it in my world. You have the stressors that they're talking about are financial, emotional, physical stressors, right? They had all these stressors, relationship issues. And so with those, you can predict that at some point I'm going to break and red room somebody because I'm stressed over money. Yeah. I'm stressed over employment. Yeah. I'm stressed within a marriage. Yeah. I'm stressed with children. Yeah. We all have those stressors, boo. I don't care if we're a millionaire or somebody who's negative $1 million. We all have stressors. And you can't sit there and say, like someone who has health issues. I mean, how do I put this? Medically speaking, she's right. If you're sedentary, I don't eat bacon every day. I don't have a high blood pressure, high cholesterol. I have I had all of those. I had high blood pressure, high cholesterol. I eat crappy all day. I sit all day. I don't move around. and I'm diabetic and I have all these things. They can predict that at some point I am a high risk for a massive catastrophic heart attack. Okay. That's a physiological thing. But what's different with physiological and psychological is free will. I can't go inside my body and have these little people sitting in my body saying, oops, danger, we're going to chip away at it. And we're going to, no, that's not how it works. Mentally, we have the ability to think. We have the ability to reason. Some of us. Now, if it's an NGRI, that's another total different stories. We choose to act on those impulses or not. I'm not saying, how many of us have said, man, I would love to take that person out? Mm-hmm. I mean, I was in a relationship with somebody for a long time, and I got in a fight with them, and I said, God, I can just kill you right now. But I didn't, because that's not what you do. It's a choice. I'm sorry. I believe that this is a bunch of hogwash. Baboons are the closest primates to humans. You're right. So why are we basing all of this off of kitty cats? How close are cats to us emotionally? Nil. Angela, you are a saint. I see what you're doing. Girl, that's I'm going to download every single one of these and I'm going to read them. But God almighty, that's insane, boo. That's a lot of documents. We're going to unload all of them. We will do a deep dive, I promise. So I guess what I'm saying is physiologically, yes, there are indicators that show high risk of a catastrophic heart attack that could potentially happen if you don't change your habits. Does not mean it will, but it could. How do we equate that over to psychological? Not by comparing us to a kitty cat. Yes, we all are going to have issues. You can prevent by the person just saying no. I don't know. I just believe at some point we all have mental stressors. All have mental stressors. All have mental stressors. Oh, thank you, Angela. You're a saint. But with something physiological, we don't have, the only control we have is to change our eating habits and our exercise and change our behaviors. Mentally, we can just say no. Like the drugs in the 80s, just say
no. That's how we work in behavioral threat assessment. And the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do, we would begin to look at the behaviors the person is demonstrating, and our being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure. That is behaviors that raise for us concern about whether or not violence might be on the horizon.
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, You still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases.
Thank you, Ari. That's correct. They show that if you want to use, oh shoot, I just said something I shouldn't have. If you want to use it to show motive, fine, let's use it to show motive. But they're wanting to use this to show that whether or not the person had committed the crime, the risk of them actually committing a crime. So you're saying they had all these stressors. We should have notified the school, work, or family members should have noticed those stressors and should have done something about it because she was going to red room somebody if nothing was done. That's bullshit. I don't believe this. I'm not trying to be mean, and I'm not as eloquent as I want to be, but I don't believe this. I call this mental hogwash, psychological babble. I want to know what person got its doctorate's degree and created the theory. Who created this in I just disagree with this.
In order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to
Okay, I don't disagree that we all have stages in certain things in our lives. I don't disagree with it. But to use this to I see this as profiling. All right, let's raise our hands, everybody. Hi, Java Queen. I got to ask y'all, do you see what they're talking about as a potential profiling instead of, do you see it as profiling? I do.
model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no
I'm Googling that one.
learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis.
Okay, it is in some, okay, depends on what side of the boat you are on this. If you're on this woman's side of the boat, definitely is acceptable. Definitely is accepted in her opinion. It's greatly widely accepted in the behavioral threat assessment and has important limitations, especially when used in courtroom setting. Now, she's saying, oh my gosh, yes, it is. Okay, let me back up. She's saying that, yes, behavioral threat assessment and forensic psychology, especially in the context involving targeted violence, such as domestic, school shootings, workplace violence. The model, and I want to talk about it so we have a clear understanding. The pathway to violence describes a progression of behaviors that individuals may experience as they move from ideation to action. Okay, I don't disagree. There are structural pathways. don't disagree. By the way, I posted a poll in my YouTube channel. Grievance. Okay, the first thing people do is they perceive an injustice and or a personal crisis. That's true. Ideation, violent thoughts or fantasies. Then they go to planning. They research the methods and target and logistics. Then they prepare, preparation, acquire the weapon, rehearsing, probing okay, and then implementation. That I don't argue with. They're probably, and that is not something that, I mean, I can disagree with. I think you can find a pattern of behavior in a lot of what we do. Okay. But let's see, I don't know if I accept it in this situation. The model is consistent with foundational in the threat assessment protocols, school safety framework, and mental health specialist programs. In courtrooms, while accepted in behavioral science, its use in criminal trials is more controversial. Now, if you want to use this behavioral pattern identificational thing for violence in psychology, when you're dealing with people and you're trying to assess what are the risks that they're going to harm themselves or others, go for it, boo. But I don't believe it is good in the courtrooms. They are trying to, do you know what? Good question. Oh, no, I believe that's a good question. I don't disagree with you on that, boo. I can't say that I do. Why did you redact it? I like the question. So hold on. So let's get back to the limit in the courtroom. Courts allow it when it helps jurors understand patterns of escalation. Yeah, that's all. That's what they're trying to do right now. They're trying to decide whether or not that this particular case is appropriate for this model. But they are restricted if it implies the defense fits a profile or is inherently violent. See, that is where you cannot use it in a court of law. I'm not saying that this may not have good uses outside the court of law, but inside the courtroom, I'm hesitant because of it can be perceived and looked at as profiling. They are also wanting experts to speak in very generalized terms and not apply the model directly to a defendant unless it is supported by extremely clear evidence. So the limitations of the pathway to violence model is it's non-predictive in individuals. Model describes patterns, not certainties. Many people experience grievances or stressors without ever becoming violent. Yep. Exactly what I was saying earlier. We all have stressors. We just don't act on the violence that goes on in our head. It's not a diagnostic tool. It cannot predict who will offend or if they will offend. The risk of profiling is misuse. It can imply someone fits the mold of violence offender when they do not. The courts have to restrict this because it's prejudiced the jurors and violates the evidentiary rules 40403. The retrospective bias on this is it applies after the crime. There's a risk of confirmation bias. Experts may interpret behaviors as fitting the model simply because the violence occurred. It can make the model seem more predictive and productive than it really is. So they can't really use it before. They can't use it before the crime actually happens. Thank you, Ari. I do have your answer. They can't sit there and say, well, we're seeing pattern A and B. We think pattern C and D is going to happen. So they can't use it until after the crime is committed. That to me is a little bit interesting. Limited culture and contextual sensitivity. The model was developed in Western law enforcement context. It may not account for cultural, relational, neurodiverse factors that influence behavior. That is so huge. If you're using a cat, you're not, oh, wait. We got some stuff going on in the Uvalde. I didn't see it pop up. We'll go there in just a second. So my problem with this is they use cats. Cats don't have cultural, neurodiverse factors or relational factors to the level that we do. Doesn't measure mental illness, trauma, or cognitive capability. It's behavioral framework, but not a psychological evaluation. That is huge. Relevance, does it help the jury understand something they couldn't see otherwise? Reliability, the experts qualified are using accepted methods. Is this acceptable or not? Depends on who you talk to. Prejudice or probative value. So in the Lori Richins hearing, what are the actual questions for the court regarding this? Can the prosecution introduce evidence of Corey Richins' alleged stressors, financial strains, marital conflict, business pressures, prior poisoning allegations, etc., through the behavioral expert without crossing into profiling and unfair prejudice? That is why they're doing this. Also, more formally, the judge is deciding, are these stress factors admissible as a part of behavioral pathway violence? That is it. The explanation under Rule 702, do they have a probative value that outweighs a prejudicial effect under Rule 403? So the relevance under 401, the judge must rule that these stress factors actually help explain what? Motive, escalation, planning, and context for alleged poisoning. Prosecution says yes, defense says no, and the speculative and inflammatory. The judge has to rule on that. The second thing the judge is going to have to rule on is expert reliability under Rule 702. This pathway to violence models, does it significantly grounded, widely accepted, reliably applied, and appropriate for this case? The judge must decide whether the expert is using recognized framework, not personal opinion. And, you know, there are a lot of different things out there that different people in the psych world use, but is it widely recognized, or is it just something that you just grabbed onto and you just like it and you're going to throw that in the boat and row the boat to shore? Applications to the defendant. Can this expert talk about stress factors in general, or can they apply them directly from Corey? Prejudice versus probative. We talked about it. So the actual question before the court is, can the prosecution use behavioral expert to frame Corey's alleged stress factors as a part of escalation towards violence without improperly suggesting that she fits a violent profile? That is the question at hand. I hope I answered it for you, Ari. That was a fabulous question. Okay, now we got, let me get to it. Uvalde school shooting is in court. Let me get it up for day 2. We are now going to switch over to Uvalde because it is our primary case. During breaks, we will continue with the Corey Richins. Let me get this up and going. We do have sound. We're waiting for the sound to come on. We are waiting on court. Once again, thank you, Court TV, for your feed. Angela, thank you so much. I will be reading through and going through all of that. Today is happening outside the presence of the jury. Let me get that up. Everybody give a good big round of applause for our mods today. Thank you so much, Maj. You're so fabulous. I'm going to make this a streamer. There we go. We have no volume in court. We are turned up, waiting on the court. I was getting hungry, y'all. It's almost 1:30. I'm going to have to get me some grub. I got me some Italian from El Pasto. Oh, if y'all are ever in Curveball and you want good pasta or Italian, go to El Pasto. If you want good fish, Wahoo's. Okay, wait, I see more questions that popped up. Let me grab those. I understand the idea of structural pathways, but what's the actual question the court is regarding this? I'm not understanding what they're actually, I read that. So the question for the court, whether this expert should be allowed to testify, not just allowed to testify, but to what extent. And if the testimony is going to come across as profiling, that's the question. As soon as they go live in sound, I'm going to take a comfort break. I got to grab me a bite. I got to. I'm ravishing here. I'm ravished. I'm ravished. All right, Your Honor. Let's get. Oh. We do not have volume. What is going on? He's just sitting there reading. Okay. So we'll keep an eye on the we don't need to listen to the entire arguments of this, but it will be interesting to see what and or what the yes. So as soon as we get an answer to this, we will as I hope I've answered most of your questions. But the let me see the
where we see this happening. But it wasn't an expert witness exactly. It was a detective who was testifying based upon experience. And based on his experience, he said that in all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
The key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some outside of most who don't know.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case, Ms. Amon is not an experienced witness. She didn't write this. She hasn't done, she can't get up there and say what the detective said in that case because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to see if we see it the same way? I agree with the defense that under cases like United States versus Wells, the expert testimony that Ms. Amon offers cannot be used in the state's case in chief and cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though, the issue, based on the briefing, is more nuanced. It seems to me that the state could use Ms. Amon's expert testimony in its rebuttal case and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical, generalized argument made by the defense, then I think this testimony from Ms. Amon, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say, well, we've showed you elements of plan and preparation on behalf of Ms. Richins. You heard Ms. Amon, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical, generalized statement from the defense that this is simply not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Well, first of all, this would be the first time that it's ever used that way. You heard Ms. Amon, this has never been used.
Well, that may be because it'd be the first time that a defense has ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well, we may not. But I think it's never been used because it's not reliable. The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time.
But they're not using it predictive in my hypothetical. They're only using it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right.
It's
I'm agreeing
not.
with you on that. We're past that.
All right. So my point is that when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form to look at this sort of instance.
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure, but nonetheless, stay focused with me. Why wouldn't that be helpful to the trier of fact under 702A to understand some?
Okay, guys, I do have my lunch. I'm trying to eat. We are back in court in the Uvalde trial. We're going to hop on over.
With the filing system and this our defense strategy, it's what you asked for. I would just ask, I know
It'll be
you'll have to
sealed.
file it, but you ask that it be sealed after you.
I'm here. I'm just eating.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflects that I'm tendering to the court my notes, all of my notes. To the court, my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th is when I started pulling the witness interviews with the Rangers that I reviewed her actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced. And I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Okay. Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this, under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but if you're making your motion for mistrial, I will tell you, I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building. And she puts, I believe she marked in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So
Casings are only going to be found where shots were fired. Casings aren't going to be found where he traveled from A to B if he didn't fire between A and B. So casings do not necessarily guarantee that he was not in the area in which she testified, in my humble opinion. If I'm on the jury, that's the way I'm going to be thinking. Casings only indicate where shots were actually fired.
A witness from 100 yards away, placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Melanie Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well,
that's true.
I did a little research last.
Good one. That's true too. I'm just saying, welcome in the house. You're right. They don't give you timestamps either.
Evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again,
Yes, Your Honor, in addition to-
Not surprised.
But make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides if we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the only.
yeah, again, I'm going to deny the motion for mistrial over your objection, obviously. And I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent. And I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy.
Okay, I don't believe that to be true unless you discuss it with the jurors. How do you know? There may be jurors on there that are like all over list, like white on rice, and other ones are. So you can't get in the mind of the jury, Your Honor.
But what I am going to do under Heath is I'm going to exclude her testimony.
We have before you do that, really, I just want to know we have a response to if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is
Can't put the crap back in the horse.
It's going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that. And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, sir. It's not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motion. So I just want to file that with the court for the court's consideration. If you could file this copy too.
Okay, well,
And that's my copy.
Good.
The first copy is for the judge. I'm sorry.
okay, thank you.
I just want to file some copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written? Did you file something?
No.
Okay.
This is just anticipation of an oral motion to
Okay.
exclude, Your Honor.
Okay.
I don't know, Your Honor, can we confer as to possible remedies? And see if we can come up with a solution. Would the court be open to that?
I mean, if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, If you want to, just go back to my office. I'll stay here and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's.
Or you can go, actually you can go to the jury room if you want to, because nobody's there.
Okay, so they are on break for the 15 minutes. Let's talk about this. Disagree with the judge, but he seems reasonable. Well, let's talk about this. Granting the continuance, which is the pause, which he's done, gives the defense time to investigate the new information, restores fairness without blowing up the entire trial. And it is least a disruptive option for the court and the families. The judge often prefers this when the violation appears negligent or non-intentional. The negatives for this is it delays the jury may lose momentum or the emotional continuity. The defense may argue continuance is not enough. Allowing the defense to re-interview the witness and recross. Now that is direct. Okay, the pros directly address the harm. Defense gets to confront the inconsistency, preserves the witness testimony while enduring fairness, and least prejudicial to the prosecution. The cons, if the inconsistency is major, which in his case it is, it may not cure the prejudice. Defense may argue damages is already done in front of the jury, and they can. You can't put the crap back in the horse, but you can deal with it. Excluding the witness testimony, it's a strong remedy if the state failed to disclose material evidence, sends a message that discovery violations have consequences, protects the defense's right to due process. Cons is a key witness whose testimony places the shooter near Gonzales. Excluding her could severely weaken the prosecution's case, and the families may see this as state is losing on technicality. Now, they're not going to declare a mistrial, and they're not going to dismiss the charges. So, right now, that is where we sit. We're just waiting. So we're going to go back over to Richins.
We know because we've studied killings that have actually occurred. Sometimes they're planned. Sometimes they take time for that plan to develop.
I guess I don't understand how that's helpful. Yes, isn't that general knowledge that sometimes killings are planned? I don't understand.
Know if it is or not, but it's that would be like if the defense is going to make the argument, these things are never planned. This is simply not the way it works. Now, I don't know if you're going to make that argument, but you're asking me to exclude Ms. Amen under any circumstance, and I'm not sure you've carried that water.
Well, we're asking that she be excluded because it's under I'm going to move also under 403 and 404B. It's highly prejudicial for someone to get up there and tell a jury, I'm an expert, and it's if we were to make that argument, which I don't know, let's see, we were to make the argument, she's a mother, she wouldn't have killed the father of her children. How prejudicial is it for someone to get up who claims they're an expert, who's not an expert, never has testified, never has used the study in this way, and then tell a jury why we're wrong?
You changed my hypothetical. Ms. Amen doesn't comment in any way on the specifics of one mother killing her husband or the father of her children. I'm not suggesting you can't make the argument that Corey Richins had so much to lose by doing this, it reduces the likelihood that she did it.
But that opens the door for Ms. Amen to come in under your hypothetical
No,
to
it
say,
does not.
no, that could happen.
Please stay focused.
Okay.
A general, absolute, categorical statement by defendant. Murder doesn't happen.
Please stay focused. Love it.
Emotional. They're always in response to a threat. They're always as part of a fight or as part of a criminal enterprise. I don't know what you'd say, but if you want me to exclude her entirely, I'd have to say that there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that, in your view, the only way her testimony could be relevant is if the defense says this kind
Don't
of
give it away.
only happen in a enraged emotional state
Yeah, or in response to a threat.
or in response to a threat. That's the
Right.
only way this is coming in.
Right. That seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's ruling, that it's only coming in under one specific circumstance. I just think our general objection, though, is that it's just not reliable under 702 under any circumstance. It doesn't matter what the circumstance is. I think that
This is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
well, one of many,
Sure.
it's not.
Now, that would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case, there are competing expert testimonies regarding the standard of care and whether it was breached. And they're both admissible, and it all goes to weight, not admissibility.
I thought about that as I was listening to her testimony. And I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge. And
Or
they
their
might have
education,
different,
training, and experience. They're not citing studies most of the time.
but it's based in science. You can get two experts who have a different opinion when they apply the science, but this isn't any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert in Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
In Utah,
applying.
he would have to be qualified as one in order to say what he said.
I can see that in federal court all the time. They're applying their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Amon wants to testify to. It's very different.
I think the rigor of Ms. Amon's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but
This goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these decisions.
that's correct. But if none of the studies have to do with a domestic violence case, how is that helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyways.
And I think one of the other problems is when she stated you can go all the way down the pathway of violence and then they don't commit a murder. So how is that even helpful?
That increases the reliability of her testimony instead of decreasing it, because it acknowledges that there are people on the pathway that fall off. So it's a most, not all, a la Diaz.
Okay.
You're going to want the last word, because I think
All right,
it's going
I'm
to
good,
quibble
yes.
with my ruling here. Ms. Charbonnet.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Amon would offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that they, being the jury, could use the analytical framework of the pathway to violence, taking the facts that they've heard presented or theories that they've heard presented through witnesses, and applying them to a framework that Ms. Amon lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding how this case could play out, how it explains a theory or rebuts a theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply. And that would be up to the jury to decide. But given the type of testimony that Ms. Amon proffered and that we expect her to present as a rebuttal witness, it fits solely within 702, and for those reasons, it's admissible.
Okay, I understand the state's position. Ms. Lewis, anything further?
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that to admit this is reliable under Rule 702 in any matter, I think is inappropriate.
Okay. All right. All right. The issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rules 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred. And based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amon is qualified as an expert in this field. And the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States versus Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Amon's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt. However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Amon's testimony regarding the retrospective study of completed killings, showing a feature such as a preparation and plan over time would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Corey Richins did not commit these crimes, and one of the reasons you can be sure of that is because Corey Richins had so much to lose in her personal life and her family life, if she had, that is a case-specific level that Ms. Ammon's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Ammon's testimony would be helpful to the trial of fact in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value, because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Ammon will ever be called to testify is also pretty low. But fact remains that there is not a basis to grant defendant's motion in full, because there is a cognizable basis upon which her blind expert testimony would be helpful to the trial of fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So, the defendant's motion to exclude Ms. Ammon's testimony is granted in part and denied in part. She cannot testify in the state's case in chief. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Corey Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Ammon's testimony should be allowed in rebuttal. Let me pause there for a moment. Ms. Shervinack, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Lewis, where would you like to go next?
I guess we're Mr. Throckmorton would be
Okay.
next. So Ms. Nestor will be. Do you want to move or are you okay there?
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the,
Wherever you're
I hate
comfortable,
bending
please.
over to
Yep.
reach that microphone. May it please the court, good morning.
Okay, so what we're doing, I know they're back. I know. But I am wanting to let that play out. We'll go back and dive into that in a minute. Now we're going back to Texas.
The clerk is sealing those documents as we speak.
Thank you.
You good? Okay, she's ready to go. So once again, we're outside the presence of the jury, and I've given counsel an opportunity to confer on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
yeah,
that part would feel.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy or in emotional impact, we would add that, and we do believe that under our 403 motion and motion of limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance, because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children are, the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear, because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claim.
I want it on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute?
Yeah, and I guess yes, I think just the court understanding, willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now and like she just goes away is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Right. You see what I mean? And so, so what it does is it puts us in a situation where that remedy could actually harm our client worse. All right.
Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning. and then I'll make a decision on exclusion with everybody's participation after we rest and, or actually she's finished with redirect and recross, whatever the case may be.
Yes, Your Honor.
But my recollection is she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement, and then that's when this issue came up, and so I would just continue with the cross-examination.
They've passed her and she's on cross.
Yes, Your
now.
Honor.
Okay. All right. Very good. All right. So 9 o'clock tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.
Okay. So let me get this back up, but we'll talk about that. I don't believe the judge is happy, but he wanted to just exclude her testimony and move on. I get where the defense is coming from. The defense is saying, hey, wait a minute. Let me delete this. Yes, delete that scene. It appears to me that the defense wants to not only continue to question her, but to show the jury the inconsistencies, because sometimes you can't put the crap back in the horse, but you can, if you just sweep it too quickly aside, then it's like, we saw the crap, but where did it go? And why don't we know more? And what are they hiding? If you deal with the crap, I think in this situation is better. In my humblest of opinions, I'm not an attorney, but if I'm sitting on the jury and obviously they know something's wrong, I'd rather have an explanation and go, okay, all right, this is what happened. They impeach her, they do this. And then the judge says, we're excluding her testimony. You cannot use it in your deliberations. Then I'm going to go, okay. But if you just sweep the crap out of the way quickly, I know the horse crapped. I saw it hit the ground, but poof, it be gone. I'm going to go, why? What happened? And you're telling me I can't consider it, but why? I'm that kind of person. There are some people who can sit there and say, he said, nope, nope's it. I don't care. I'm not going to think about it. I could be that way somewhat, but I think, in my humble opinion, if I'm on the jury, I prefer the method in which they're choosing. Now over to the Corey Richins. Now, under Corey Richins, they won and they lost. It's a draw. Corey Richins came to a draw, meaning the prosecution cannot bring into evidence this expert witness on their case in chief. But if the defense opens the door, then they can bring her in. That is where we are. And that happens a lot in trial. So I'm not surprised that that was the verdict. But it puts all the power in the defense's hands. All right, we're going to get going into this courtroom.
Your Honor, as far as Mr. Throckmorton's testimony, the objections that we have to his testimony, it's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact. And the main concern is his conclusions or lack thereof are basically, I looked at this, I cannot say at all whether Corey Richins signed Eric Richins' name or didn't. I can't say she did. I can't say she didn't.
Right. You skipped a step though.
Right. Well, I'm getting.
I mean, he does say with a much higher level of probability,
right,
that Eric Richins didn't sign it.
Right.
He just can't say that it was with the same level of probability or any, depending on the document,
right,
that it was Corey Richins that made the simulated forgeries.
Right. And the concern that we have is his materials that he provided and that we expect would be laid forward before the jury. Take little pictures of letters and compare them. And, all of us are human and we all have eyeballs, or those of us blessed with the sight have eyeballs that work. And we are tempted to look at those things and compare them and contrast them. And it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Corey Richins signed these, signed his name, signed the initials. His finding that Eric, I believe the finding he had was a strong probability
For
that
one of them.
Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff. I'm going to send this back in the jury room. Y'all can sit there and look at these initials. You can try to figure it out yourself if you think that he did it. But I'm, as an expert, saying I can't say Corey Richins did.
Maybe pause there for a minute.
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well,
And
maybe.
it's not supported by the science. The second prong that we're
Pause
attacking.
with me for a minute, though.
Yeah.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right.
Okay, guys, I'm sorry. I'm a little flustered. My hearing aids have stopped connecting. So I need to reboot my hearing aids so I can follow along with you. There we go. So I'm going to come back a little bit, only because I didn't hear any of that. Here we go.
Right.
And my captioning wasn't keeping up.
With the same level of probability, or any, depending on the document, that it was Corey Richins that made the simulated forgeries.
Right. And the concern that we have is his materials that he provided and that we expect would be laid forward before the jury. Take little pictures of letters and compare them. And, all of us are human and we all have eyeballs, or those of us blessed with the sight have eyeballs that work. And we are tempted to look
Good
at
coverage.
and compare them and contrast them. And it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Corey Richins signed these, signed his name, signed the initials. His finding that Eric, I believe the finding he had was a strong probability
For one of them.
that Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff. I'm going to send this back in the jury room. Y'all can sit there and look at these initials. You can try to figure it out yourself if you think that he did it. But I'm, as an expert, saying I can't say Corey Richins did.
Maybe pause there for a minute.
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well,
And
maybe.
it's not supported by the science. The second prong that we're
Pause
attacking.
with me for a minute, though.
Yeah.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right, does Mr. Throckmorton's analysis assist the finder of fact in determining whether the state has carried its burden of showing beyond a reasonable doubt that defendant forged some documents, right? And a step along that way from the state's perspective is, well, first we need to show that Eric didn't sign them.
Right.
So focus on that moment, that part for me for a moment. Why isn't Mr. Throckmorton's testimony admissible on that part?
Well, one big reason is that the initialing, there is no statement at all that Mr. Richins, so there's two documents at play. There's a power of attorney, which according to Mr. Burmester from the county, they're not even going to get into that unless we introduce the power of attorney as an exhibit. They're not even planning on doing it in their case in chief, which I just found out this morning.
Okay.
But let's say hypothetically, for some reason, we need the power of attorney. They're not even saying he didn't sign it. Like their expert is not saying that's not his signature. They're only questioning whether he initialed each and every little blank on the side, right? Of which the expert cannot say. He cannot say he didn't. He cannot say to any degree of certainty whether Corey did. He said absolutely no conclusion as to whether Corey did, but he also can't say for sure that Eric didn't.
Well, doesn't he say that there is a strong probability that Eric Richins did not author the ER initials on the power of attorney that defendant allegedly used to obtain a HELOC?
Yes.
Okay. He's used a strong probability for that opinion, right?
Right, but that also provides for the possibility that Eric did initial it, right? I mean,
certainly,
yeah.
and the jury can weigh his testimony.
Right.
In terms of admissibility, it would seem to be helpful to the trier of fact to receive an opinion from a qualified expert as to whether Eric Richins initialed a document or not, right? Because if he didn't, it leaves open the possibility that somebody else did. And then when we go to, well, does he have an opinion as to whether Corey Richins was the one that initialed it? Right. I acknowledge that his level of certainty there is much lower, if not, there's no conclusive proof one way or the other.
Right.
But why wouldn't you want to let that in?
Right. Well,
if the state wants to call him to say it, it certainly doesn't hurt defendant.
Yeah, if he testifies at all, trust me, we do want that to come in.
Yeah.
The concern that I just have is just misleading this jury about these floating standards, because under the National Institutes of Science report, under the PCAST reports, the reliability of subjective handwriting analysis has been brought into serious question by the general scientific community. I provided those materials in my brief. And to have a layer of persuasion going to the jury of an expert that is relying on a science that has not been generally accepted by the national scientific community. And I specifically identified where in the NIST report and where in the PCAST report the scientific community says, look, this is just a subjective. It's no better than if me and you and the deputy all sat down and just guessed if it looked like it matched.
Doesn't Mr. Throckmorton reference studies saying that certified handwriting analysts are better than the lay public at identifying differences in simulated forgeries?
He does, and we would obviously attack that if he took a stand vigorously. But yes, he does. He states that in his report, which may be enough to get you past the gatekeeping requirement. That's up to the court. I do also have some real concerns about whether portions of this needs to be redacted. One of the conclusions he was asked to, or he wasn't even asked, he did it sua sponte, I think only applies if it's a court, but he did it on his own when he was submitted the documents in question. One of the documents he was submitted on the amended report as recently as a few months ago. Now we're 3 years after the death, and he's just now being submitted new evidence, right, to evaluate. But that's what happened. And they gave him a report by the like a notary page where the notary had signed. And he just on his own makes a conclusion that a date has been altered, a number, not a letter, not handwriting. There's no evidence whatsoever that either that was asked of him to do, that he's qualified to do that there's any science backing that up.
I don't know that the state's offering that opinion at trial. Am I right about that, Mr. Burmester?
I don't even know what she's talking about.
Okay, so it sounds like a no.
Okay, well then if that report comes in, we're going to ask to redact that section of
Reports
it.
don't come in, they're hearsay.
Okay.
His demonstratives may come in.
Okay.
He usually he does in fact have demonstratives, and those
2025 was
but the report's hearsay.
Right. And also whether or not, that'll go to wait. We'll deal with that when he takes the stand. So I think really that it's really a two-based argument that we presented to the court. Two bases for our argument. One is that we don't believe it's helpful because there is no conclusion. Number two, we question the science of handwriting analysis. I provided the court with the scientific community's concern about the reliability of handwriting analysis, that it's really slowly but surely being relegated to junk science. And on that ground, we think, and what it adds is minuscule. It provides no guidance to the jury. So as far as we're concerned, if you're going to exercise a gatekeeping function at this point, this would be the point to do it. And we would ask that he be prohibited from testifying as an expert in this case.
Okay, you'll get the last word.
Yep.
Mr. Burmester.
To clarify, the state would offer Q1, Q2, Q4 in the event arguments come out in the defense case in chief. I don't know, we come up with 100 hypotheticals, but maybe something, she's a great businesswoman and somehow puts into question evidence that we might offer, which could include that power of attorney.
And Q1 and Q2 are definitely the power of attorney. Is Q4 also?
Q4 is when Mr. Throckmorton is asked, all right, we have some knowns from Ms. Richins.
Right.
Now, do the same thing you did.
Okay.
So with regard to those would only, that is how I would see us calling Mr. Throckmorton in rebuttal. Main point is there's not an agreement that they have to introduce the power of attorney before we would introduce it. It would be a whole set of facts that might make that come about.
Is the power of attorney, forgive me, I didn't go back and look, is the power of attorney the basis of one of the forgery charges?
It is not.
Okay. So why would the power of attorney be discussed in your case in chief at all?
Oh, I'm not offering the case in chief.
Okay,
That's
got it.
precisely why.
I see.
It would have to be some facts that arise in the defense case.
Got it.
That would implicate offering that exhibit, and therefore its authenticity would be an issue.
Understood.
Okay. So that leaves us with just the true stage
application signature, which is indeed at issue, identity of the forger and identity of that insurance fraud count.
So there, I understand the state's argument to be Mr. Throckmorton helps the trier of fact determine whether we've carried our burden on the forgery count related to that insurance application, because he says, he opines that it was probably not authored by Eric Richins, and it appears to be a simulated forgery, full
Correct.
stop.
Yes.
Okay. And that, in the state's view, is circumstantial evidence that makes it more likely that it was forged by Ms. Richins.
Yes.
Given other factors related to motive, access, et cetera.
Yes.
Okay.
Yeah, I get this. I was in the courtroom in Gersh v. Gersh, and so I know the court is familiar with Mr. Throckmorton, and we've proffered all those in our pleadings, all his qualifications. So I don't intend to talk about that. However, there is a notion, and Mr. Throckmorton is here, President Court, we can call him as a witness. He would talk about how handwriting comparison has been used in courts for 200 years. And since the 70s, there's been an intense professionalization of that theory. And that history goes to prong C for demonstrating its threshold. I would also just like to address two other things, and that is the pathway forward, 2009, where the scientific committee who's addressing what is the status of every single forensic science, and there's a portion about handwriting, and the committee agrees that there may be some value in handwriting analysis. The scientists who composed this document, of course, hold DNA at that time as being the gold standard. Obviously stated there were some things that need to be addressed, but certainly doesn't say it ought not be admitted. PCAST doesn't even directly address handwriting. It says all these other sciences like handwriting, these same things should be applied to them. But none of them say scientific community is rallying around some notion that it's junk science.
Certainly not in the state of Utah. I've looked. I cannot identify any time that Mr. Throckmorton has been excluded in the state of Utah. I can only find cases in which he's been admitted as an expert.
Unless the court has further questions.
I understand the state's position. Ms. Nestor.
Nothing else, Your Honor.
Okay. Before the court is the defendant's motion to exclude the expert testimony of Matt Throckmorton. Mr. Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature. In addition, Mr. Throckmorton has been noticed as someone who may offer testimony in rebuttal or impeachment that there is a strong probability that Eric Richins did not author the ER initials on a power of attorney that the defendant allegedly used to obtain a HELOC on the Richins home, and that there are mere indications that the defendant wrote those initials. The court determines under Rule 702A that testimony, which would come in the state's case in chief and perhaps in rebuttal, respectively, is helpful to the trier of fact because it would assist the trier of fact in determining whether the state had met its burden to show that Ms. Richins committed the charged forgery count regarding the True Stage insurance application, and may be relevant to show Ms. Richins' conduct related to the HELOC in rebuttal. Moreover, based upon the court's review of Mr. Throckmorton's CV, his education, training, experience, and his substantial history and experience in testifying, certainly in state courts in the state of Utah, the court finds that he is qualified as an expert in the field of handwriting analysis. Regarding defendants' objection to the reliability of Mr. Throckmorton's analysis, the court finds that his analysis and his methodology, and therefore his testimony, are sufficiently reliable under both rules 702 subsections B and C. Under C, the court finds that Mr. Throckmorton's analysis, because it is performed consistent with and measured against the SWIG-DOC standards, is generally accepted by the relevant handwriting analysis community. Moreover, even putting that aside, the court determines that his methods are reliable in as much as he is able to describe the way he compares the questioned documents to known samples of both Mr. Richins, the decedent, and also Ms. Richins, the defendant. He applies that reliable methodology to a sufficient set of known signatures, and he does so in a way that does not ignore any uncontroverted features of those signatures or other uncontroverted facts. That is, he applies his methodology to a sufficient set of facts or data in a reliable manner. Therefore, his testimony is admissible under Rule 702B. Finally, the court is not persuaded that his testimony, the probative value of which has been described, is substantially outweighed by the danger of unfair prejudice or other concerns under Rule 403. For these reasons, the defendant's motion to exclude Mr. Throckmorton in his entirety as an expert witness is respectfully denied. Mr. Burmester, do you need any clarification in the court's room?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Next.
Ms.
Okay.
Oh, sorry. They're screwed. The defense is not winning what they want today. They are definitely on an uphill battle. The fingerprint expert will come in for the prosecution.
Handling that one.
Very good. You ready to turn to Dr. Venino, Ms. Nestor? Ms. Shervanek, is this one yours?
Yes, Your Honor.
May I ask you a couple of questions?
Yes.
Thank you, honey.
Okay.
By the way, I think she's still handcuffed. I don't know.
Ms. Shervanek,
No, she's not.
any admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14 of 2022?
I don't believe that would be presented in the state's case in chief.
Okay. Is there any admissible evidence that Eric Richins had any subjective knowledge that defendant attempted to poison him on February 14, 2022?
That he had knowledge of it?
Right.
Yes.
Tell me what admissible evidence there is of that. We went through this for a couple of hours with Mr. Wright.
We did.
I spent some time on this yesterday. I don't know that there's any other admissible evidence that would show that Mr. Richins knew that anybody had attempted to hurt him.
May I have a moment?
Of course.
So other than Animal Crossing, other than them there's no evidence other than hearsay that someone had tried to unalive him before. Y'all, here's my Animal Crossing.
I think the court is aware of what the admissible evidence is, the testimony from Josh Hayes and Cody Wright, that
Cody Wright's not going to testify, as I understand it, trial pursuant to, not at least regarding the events of February 14, 2022. I don't think he has any admissible testimony regarding that day.
He does. His admissible testimony are his observations, not the content of Eric Richins' conversation, but his observations about Eric Richins' demeanor.
You didn't see him. It was all on the phone.
Right, but his hearing observations about his voice, how he seemingly sounded on the phone during those conversations, and not the content that aren't admissible because of hearsay rules. But there are observations that he could make through that phone call that is admissible.
Proffer that for me.
This is exactly what Mr. Wright testified to previously.
I don't know that he can give that testimony regarding his observation of the manner in which he was talking without saying what he was saying.
I disagree.
You're proffering that Mr. Wright would say he sounded scared?
That he sounded somber, that he sounded concerned. I don't remember the exact words that he used when he testified, so I don't want to misstate those. But certainly he testified that during that phone call, Mr. Richins had a certain demeanor that struck him and that he remembered, and then he testified to what that demeanor was.
Okay. All right, let's assume that comes in. Anything else?
There are also text messages between the defendant and Eric Richins about the sandwich that was left. And
so let's be specific. There's a text message from June between defendant and her friend indicating that she left a sandwich. And then there's a text message from Eric to Corey at 11:33 a.m. on February 14 saying he's not feeling well. I'm going to go lay down. If I don't feel well, I'll go to the hospital. Anything else?
later in the day. Sorry, I don't have all of those messages at the forefront of my mind.
That's okay.
Your Honor, late in the day, late afternoon on February the 14th, there are text messages between the defendant and Eric Richins, which he doesn't directly say something like, you just tried to poison me.
No.
But the state will argue that his messages and her non-responses for several hours, and then their ultimate exchange about he says something like, I got dinner for you and left it on the seat of your car or on the seat of my car. The state will argue that those indicate he was well aware of what happened on February 14th at about 11 a.m.
Okay. All right. Okay. My concern is that in the absence of admissible evidence, in the absence of the jury hearing the content of Mr. Richins' statements to Cody Wright, there isn't a basis for the jury to conclude that Mr. Richins was acting inconsistently by staying with Ms. Richins or not doing something more acute between February 14 and the day he ultimately died. And without a reasonable basis to find that he acted inconsistently, I'm not sure why Dr. Venino's testimony is helpful to the trier of fact. And I'm more concerned that under 403, it would invite the jury to speculate about whether there was, in fact, a prior history or prior experiences of domestic violence that aren't in the record.
I think there are other instances, other facts that would be presented at our case in chief that are maybe not on their face what people typically consider domestic violence, meaning physical abuse. And that's the crux of it. For example, if there is infidelity, why do you stay in a relationship? For example,
But
if
does Dr.
someone is,
Venino have anything to say about that?
what's that?
Does Dr. Venino have anything to say about that?
I think these go to the counterintuitive behaviors. These go to manipulation and control that exist outside of physical abuse in these types of relationships, which is exactly what needs to be explained, because the jurors may have questions of, why wouldn't you leave if you knew you were being cheated on? Why wouldn't you leave if you thought this person was taking your money?
Well, hold on. The jurors, lay jurors, are perfectly capable of figuring the first one out in their everyday experience. The second one as well. The state, I think, has a more thought-provoking point of, if you knew somebody tried to kill you, why'd you stay with them? Now that, I understand, would require or may allow the admission of specialized knowledge regarding domestic violence relationships and cases. I got that. That's, I think, a valid argument. I'm just not sure there's any foundation for the jury to conclude that this relationship involved domestic violence before Mr. Richins ultimately died.
I think that the court is considering this as domestic violence in the context of a typical physical abuse case that we're not alleging.
I'm not suggesting otherwise. I'm more concerned with Dr. Venino talking about it that way.
And she would not.
Then what does she do that's helpful?
It's in her proffer. She can certainly testify to it, but it is the counterintuitive behaviors, it's power and control and manipulation outside of physical abuse that does not include physical abuse.
Okay. All right. Mr. Bloodworth, did you want to add anything?
Yes, Your Honor, thank you. As it relates to what I would most likely expect the testimony to involve Valentine's Day is why not? Why if you thought she just murdered you, do you still stay?
Right.
And it seems to me that where the court might be hung up is in the probative value of the evidence showing that he knew versus
Or lack thereof, or just lack of evidence showing that he knew.
the probative evidence showing that he knew versus the prejudice that would come along with perhaps an improper inference.
An improper inference of something prior to February 14th.
Prior to February the 14th,
Right.
correct, Your Honor. So I don't know that at this point in time, the court has the full amount of evidence that Eric knew, despite kind of some proffers just now. this may be a decision that the court wants to reserve on under the scope, kind of make the reservation of the court needs to hear the evidence that Eric knew. Upon hearing the evidence that Eric knew, the court can make a 403 decision. I think the court can make probably the 702 decision part of that today, but I think the court needs more information on the probative value of the evidence that Eric knew.
Okay. Pause there for a minute.
Yes, sir.
Ms. Nesser.
Your Honor, Ms. Dr. Venino, I think
You called?
She has certainly not been identified as a family relations expert, a good or bad marriage expert, a marriage counselor.
I know, but respond to what Mr. Blightworth just said.
That's what I'm trying to get to. So if they're trying to argue that there's been infidelity or there's been arguments in their marriage, infidelity on both sides of their marriage, which is an answer to a question about why you wouldn't leave. But that goes way beyond what the narrow area that she's qualified in. She's qualified in domestic violence. If you look at her CV, 99% of it deals with sexual assault victims. A tiny percent of it deals with domestic violence in the home that is not connected to sexual assault. Almost all of it's connected to sexual assault. So her specialty, while they may want to put that case on that, that she was a bad wife or whatever they want to try to argue, this expert is being called to opine about violence in the home, not just being a bad wife or being, controlling or manipulative of your spouse, but of a spouse being in fear due to emotional or physical coercion to the point of being in fear. And there's zero evidence that I've seen in 10 terabytes. What are we up to? 12 terabytes? 12 terabytes of discovery. And if they've got some evidence out there that there was domestic violence in this relationship and I don't have it yet, I submit it's not coming in.
Wow. Whoa. Let's stop. 12 terabytes. Do you have any idea how many pages of paper that is? Oh my gosh, y'all. And yeah, if there's no evidence of domestic violence that they have seen in the 12 terabytes, I feel sorry for the legal people all the little paralegals that have to go through 12 terabytes of information. Oh, that is definitely a rainbow unicorn poo ton of documents. So if that's the case and there's no evidence of domestic violence, there's not going to be any.
The prejudice would be outrageous to allow this witness to get on the stand and opine expertly that because there were problems in the marriage, that this was a situation that put Eric Richins in fear of domestic violence.
That's not what Mr. Bloodworth was arguing. He was arguing that I should wait to see how the evidence comes in the state's case in chief to determine whether they've laid a foundation for the jury to draw a reasonable inference that Eric Richins did in fact conclude subjectively that
no.
And then stayed with her. If they do,
guess. All right, without Googling, because I just did. I Googled it. How many pages paper would it be? All right, here's what I said. If you printed 12 terabytes of information, how many pages would it be? Y'all. Get a used switch. I have the big screen where the handles come off, not the new one, but the one behind it. Accessory kit. Yeah. I agree with you. Somebody else is getting a switch. They just don't know about it. But anyway, can you guess billions? No, not even a trillion. 6 trillion pages. If you had to print 12 terabytes, it equals to 1.1 terabyte of plain text equals 500 billion pages. If you were to print 6 trillion pages of paper and stack them, the paper tower would reach the moon and back multiple times. It will fill millions of filing cabinets, require over 30 million boxes of printer pages. Huh. Does that not put that in perspective for us? That's a shite ton of information.
I think their argument that
I don't even think Karen Reed had 12 terabytes of information.
Dr. Venino's
Of evidence.
testimony is helpful with the trier of fact is stronger, and we can have a conversation about it today or tomorrow or in the future. If they don't lay the foundation, I don't think it can come in because it won't be helpful to the trier of fact. And even if it had some minimal helpfulness, it's the danger of inviting the jury to speculate about whether there was some other history prior to February 14 regarding domestic violence, whether they've misheard the evidence and are confused or misled. That's too high under 403. But Mr. Bloodworth's point on behalf of the state is, rather than doing this by proffer, why don't you just hear it come in and then decide if we can call Dr. Venino after we've tried to lay the foundation for what we think we're going to be able to show.
Well, one of the problems is, if she's going to come in, there's things we as lawyers need to do to prepare for that. One thing, we may want to get a rebuttal witness. We honestly did not believe that her testimony would ever come in at this trial because there's zero evidence of domestic violence on Corey's part, right? So there are things we need to do to prepare that preparing at the last minute puts us at a significant disadvantage. I think you're always entitled to revisit any ruling you ever make, right? You're the judge. You can revisit a ruling at any point in a trial if the evidence changes or something changes.
Certainly.
But as this evidence stands right now, they have not propounded evidence sufficient to get her testimony in at this point. If they do that later, then they can ask you to reconsider. But right now, I think the only proper ruling would be to rule that there's no standing right now to let her testify. If that changes, you can reconsider it. But right now, they've not propounded that evidence. I've never seen that evidence. And we're, a month out from trial. I seriously doubt we're ever going to see it. But that's what we would ask you to do at this point.
You acknowledge there's a little bit of internal inconsistency to what you just said. I agree with the last part that I can say, well, she can't testify until you lay foundation.
Right.
But once I say they've laid foundation, you're going to be right on the horns of the same dilemma you just described in terms of needing to have a rebuttal expert prepared to go.
Right.
Okay.
Well, I mean, if it depends on your ruling, how we approach that, right? I mean,
talk to me about, assume that there was foundation in the record today, that there was admissible evidence that Eric Richins had a subjective belief, well-founded or otherwise, that Ms. Richins attempted to poison him on February 14, 2022, and elected not to do anything about it. It would seem that that would satisfy the 702A standard for helpfulness for the jury in terms of explaining why people who suffer violence in a domestic relationship don't immediately get out of it.
that still doesn't mean that there's any evidence of that violence in the relationship. Even if
You got to
that,
accept my hypothetical.
right.
That he subjectively believed that she did and didn't get out. That would seem to open the door to Dr. Venino's testimony as helpful to the trier of fact. Do you disagree?
I would disagree with that.
Tell me
obviously. Well, based on her area of expertise, as I read her proffer, her theory is, it's almost like we use the word grooming in child sexual assault material cases, but that idea of being in such a violent and traumatic relationship that basically a person just gives up. It's kind of the
Well,
burning
that's
bed.
not what she says. I mean, quote, there are many reasons that a victim of intimate partner abuse doesn't simply leave an abusive relationship, including love/hope for change, economic constraints, lack of perceived acceptable alternatives, social isolation, and fear.
Right. There's no evidence of any of that. In the
No,
very
but in my hypothetical, there would be evidence that he believed that was the case.
Okay. Accepting that hypothetical, that evidence that does not exist now somehow appears at trial for the first time ever,
right,
and is allowed in, even though we object like crazy because they didn't give it to us before. The argument would be that her testimony, my understanding is she's a blind expert, right?
Right.
So she's not going to be able to take that evidence and analyze it anyway. So how does it change her position at all from right now?
Well, because right now, in the absence of the foundation that you assert is missing, that I have concerns is missing, that Mr. Bloodworth is saying, hold the phone, let us lay it at trial. I agree that her testimony would be unhelpful because it's not relevant to
Right.
the facts of the case.
Right.
If they lay the foundation, it suddenly becomes relevant to the facts of the case.
I don't know. I think it gets very, very painfully close to opining on the mental state. I mean, it's the same argument that you raised before when you were talking about the testimony of the profiler, right? Like, how close are you going to walk to that line that you're giving an expert opinion about what's inside someone's brain and then extrapolating that, one step over to defense counsel table, right? And I mean, basically her testimony would be under circumstances where someone believes that their life is in danger, it's perfectly rational for them to stay. So it must show that they did believe it, but that they just didn't act on it. I mean, she's opining on what would be in Eric Richins.
They'd offer her testimony for the inverse.
Right.
The fact that he didn't leave is not necessarily an indication that an attempt in his life didn't happen on February 14th.
I mean, I had a case very similar to this one time. I had a rape case where the victim of the alleged rape testified wholly inconsistently, like 6 different times about what happened to her,
right,
to the extent of like where it happened, how often it happened, in what position it happened. Everything was just absolutely in every statement she gave. And the federal government called a witness to testify, an expert, to testify that rape victims are more likely to be confused. So the fact that her statements are consistent with trauma and make it more likely that she was a rape victim, right? And we have this huge battle over that, about how far can you use an expert to explain away your inconsistent evidence, right? Evidence that's inconsistent with guilt. And it shouldn't be that you should be able to call an expert witness and say, hey, we're presenting something that's wholly illogical and irrational, but we're going to call this expert up here and say, well, this certainly would be a perfectly honest reason why Mr. Richins would believe that, it was a healthy thing to stay with someone who just tried to murder him, right? And so it eliminates their problem with their evidence, and it goes into his state of mind, which an expert shouldn't be called to testify about.
Well, we could talk about that under Diaz.
Right.
But, okay, I understand your position. Ms. Shervanek, Mr. Bloodworth, anything else today?
No, sir.
Okay. Let me take it. Oh, I'm sorry.
Sorry, Your Honor.
That's okay. Anything else on the record at the moment?
No, sir.
Let me take a 10-minute break. Okay, thank you.
So they're taking a 10-minute break. So we're going to, well, actually, no, we're going to zoom through their break. Zoom. I am showing her my island. I hope y'all don't mind. Tracy was the only friend that I had that did Animal Crossing. So it was just between she and I. I've had Animal Crossing about 2 years. It's one of my islands the way it is. And I don't have any friends to come over anymore. So, honey, if you want to come visit me, let me know when you go live, when you go on your game, if you can fly yet. I don't know if you can fly me to the moon. My thing is all wrinkled. Hold on. If you can fly yet and come visit me, I'll send you a dodo code, and then you can come with empty pockets. Oh, I'm maxed out, and I got a ton. Oh, wait. You do what? You played the turnip market? Did you go buy a turnip and go turn it in on a treasure island and max out your bills? Huh? But I love to go over and visit with you. I love going to different islands and so you ought to do me a private message me in Discord, your friend, your thing, so we can request friendships. I didn't do that. Tracy didn't tell me about that until like into my first year. I was like, bitch, please. I built all this by myself. And you mean to tell me I could have bought it all? Yeah, now I'm rich. Now me so rich, but my island needs a lot of work. It's very empty right now. Yeah, first of all, I just need your name and all of that. Whatever you sign on as, and I'll try and find you. But anyway, we'll figure it out. Back to court.
Dr. Sherry Venino, who is an expert noticed by the state or disclosed by the state to give testimony about domestic violence relationships, to include characteristics.
Meanwhile, she's going to look at my island.
Patterns and victim trauma. Dr. Venino is disclosed as a blind expert who is being offered to testify regarding a set of principles regarding domestic violence relationships without having either viewed or opining on any case-specific evidence. The state asserts that characteristics of domestic violence victims are relevant because when applied to the facts of this case, they will help a jury understand, for example, why Eric Richins continued to live with the defendant after she allegedly administered fentanyl to him on February 14, 2022. Currently, the court has not seen in the record a non-speculative basis for the jury to draw an inference that Eric Richins had any subjective knowledge of Ms. Richins' alleged attempt to poison him on February 14, 2022. And in the absence of a non-speculative basis for the jury to draw that inference, that is, that Eric knew that his wife had attempted to hurt him, there's no relevance to Dr. Venino's testimony regarding the dynamics of domestic violence relationships, because there would be no foundation for the jury to conclude that the relationship between Corey Richins and Eric Richins qualifies as a domestic violence relationship. In the absence of that foundation, Dr. Venino's testimony would not be helpful to the trier of fact under Rule 702A, and given its lack of probative value, it would be inadmissible under Rule 403, not only as not being relevant under 401 and 402, but also under Rule 403 as inviting the jury to speculate about whether there was some other evidence of a domestic violence relationship between these two that wasn't in evidence in the court. It might confuse the jury regarding the testimony that is admissible. It might mislead them regarding the reasonable inferences to be drawn from it. So sitting here today, there isn't a basis to allow Dr. Venino to testify. However, the state makes a reasonable point that the court hasn't seen all the evidence, isn't aware of all the evidence, hasn't seen how it would come in, and the state may yet be able to lay the missing foundation during its case in chief. And so while the court determines that sitting here today, there is not a basis to allow Dr. Venino to testify. The court acknowledges that that basis may arise through the state's case in chief if the state in its case in chief lays a sufficient foundation for the jury to draw a non-speculative inference that Eric Richins was aware that defendant tried to hurt him on February 14, 2022. The court will revisit defendant's argument that Dr. Venino's testimony should nonetheless be excluded under Rule 403, given the entire context of the evidentiary record at that point. In so ruling, the court also rules that Dr. Venino is qualified to offer this type of testimony under Rule 702A, and that her testimony, if it becomes helpful to the trier of fact, and if it survives a 403 balancing test, satisfies the minimum threshold for reliability under Rule 702B. Ms. Shervinack, Mr. Bloodworth, do you need any clarification in the court's room?
No, Your Honor, that's sufficient. Thank you.
Ms. Nestor?
No, Your Honor.
Okay. All right. Any other expert witness issues we need to handle today, Ms. Lewis?
Not today, Your Honor.
No. Okay. Mr. Burmester?
No, nothing.
Ms. Shervinack?
No, Your Honor.
All right.
No, Your Honor.
Okay. Sitting here at this moment, I'm not prepared to get too deep into the other motions and limine. We take those up tomorrow. Any practical considerations that we need to think about, or are we just going to handle those one at a time tomorrow based on the papers?
Those are mostly going to be mine, Your Honor. Some of them are Ms. Lewis's. Alex has, I think, one or two. Mr. Ramos, sorry. The only question we had, and I'm just not sure. So these motions were filed privately because they deal with evidence that we're asking not be admissible at trial. I didn't know if the court intended to have the hearing public or not public, because once it's aired, it defeats the purpose of why it was all filed privately.
I mean, there is some space between the way we talk about stuff and the documents. For example, there are certain documents or transcripts in which the state is seeking to admit a portion, but not the whole thing. And it's sometimes because the part they're not seeking to admit would be unfairly prejudicial, not relevant, inflammatory.
Right.
Nonetheless, your point is well taken. Do you have a request?
Obviously it would be our preference that it all be private, and then maybe your ruling could be public.
Sure.
Because your ruling can craft it in such a way that you don't reveal inadmissible evidence. But it seems to me that the danger that a bunch of inadmissible evidence is going to be broadcast to all of our jury who now have received jury questionnaires and know they're on deck,
right,
could be problematic. So we would ask that the hearing be sealed, and then maybe just the ruling be made public.
Okay. What's the state's position?
No objection to that, Your Honor.
All right. Tomorrow, January 8th, the court has set a hearing to hear oral argument on numerous motions in limine filed by the state and by defendant related to a number of pieces of testimony, documents, audio recordings, video recordings, other pieces of evidence. The admissibility of those things is as yet undetermined. And the court is persuaded by counsel's stipulation that to ensure the integrity of voir dire and the jury pool, and in recognition of the fact that potential jurors have already filled out their questionnaires, and so there would be a reduced ability tomorrow, the day after, to investigate whether they're exposed to information regarding inadmissible evidence. The court finds that it is necessary to close tomorrow's hearing to the public and to seal the audio recording of it so that it is available only to counsel, but not to the public at large. The court's ruling regarding what is admissible and what is not will be part of the public record. Any clarification on that, Ms. Nestor?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. Folks, we're likely to get some weather tonight and tomorrow morning. Is 9:30 an appropriate time? Do you need a little more travel time?
10.
That's fine. 10 a.m., Mr. Bloodworth?
Yes, Your Honor, that works. I have one other
Please.
issue.
Go ahead.
Don't like that decision.
To answer this, but we do have a number of motions tomorrow, and in terms of expediency, it would be helpful if you have specific things you'd like us to be prepared to address. Maybe if we knew some of that in advance, if there's particular case law you want to discuss.
No, I'm going to be going off. I mean, I do have lots of practical questions about, all right, who's offering this? How's it coming in? Right? Is this case in chief? Is this in repeat? I need to understand the order of events. But I will go off the papers. And I'm happy to follow your lead in terms of the order in which you want to do things. So talk to each other. If you want to do Mr. Ramos's first so he can go do something, that's fine. Will you just tell me how you want to?
He doesn't get to leave.
Okay. Anything else, Ms.?
No, Your Honor. He doesn't get to leave. We're not doing his first so he can get out of here. No, thank you. He has to stay. If I have to be here, Your Honor, he has to be here. Oh, what a snob.
Your Honor, clarification on the ceiling.
Yeah.
Hey, popcorn jurors. Welcome.
Representative.
Just one.
Just one.
Okay.
Yeah. Would be similar to what we would do for jury selection, for example. So during individual voir dire, victim representative is allowed to be present. I don't even know if Ms. Richins wants a family member present.
I'm sorry. No, out of abundance of caution, because they've received subpoenas,
Right.
it's probably better they not.
Okay. So if you would pick a representative for the Richins family,
I think there's two that are designated.
that's fine. I understand. Yeah.
Your Honor, one more thing. The state in some of its motions have styled them as motion to pre-admit.
Right.
The defense, in some objections, had said the state lacks, or the court lacks authority to pre-admit. I don't fully know what the answer is, but.
Well, no, I certainly have the authority to say that, for example, defendant has admitted that she wrote a certain letter, so 901 is satisfied.
Sure, that. But as far as the relief the state is requesting, if the state has styled it as a motion to pre-admit, the state would like to amend any of those stylings to a motion to determine admissibility.
Understood.
Thank you.
Okay. Some of my questions will be, is there a genuine issue regarding the the authenticity
Sure.
of this document? Who's your witness that's going to bring it in? Something like that.
Yes.
Okay.
No, nothing further.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, I'm not suggesting that the defendant should do anything other than put the state to its burden of proof and require them to lay a foundation for stuff they want to admit. However, I do want you to be at least a little bit thoughtful on both sides of the V here about the juror's time and the court's time. And so if there are indisputably authentic documents that you can stipulate regarding authenticity and foundation, but you want to reserve and then discuss your arguments regarding admissibility,
Right.
let me know which one those
Your
are.
Honor, I actually have been spending a great deal of time on that. I've come up with lots and lots that we're willing to stipulate to authenticity. I told the prosecution I would get that to them, I think Monday, but something came up in my family and I wasn't able to do that, but I will try to get that to them by Friday.
Okay.
But there's quite a few documents that we're not gonna have a problem with authenticity, and we're not gonna ask them to bring in sponsoring witnesses or
Perfect.
like jail calls and
Yeah.
bank records and pictures and all that kind of stuff. And
I mean, I'm doing it one by one by one, and will have a comprehensive list by Friday, hopefully.
Thank you.
Thank you.
Okay. Mr. Bloodworth, anything else today?
No, Your Honor.
Okay. Ms. Lewis?
No, Your Honor.
All right. We'll reconvene 10 a.m. tomorrow morning. 2 victim representatives are welcome to attend. The rest of the public will be excluded tomorrow. Please travel safe.
Dang it.
See all of you. Please take care. Court's in recess.
Dang it. That's not what I wanted to hear. Well, that's okay because we got other trials, y'all. We got other things to be doing. So January 8th at 10 a.m. Mountain Time, hearing closed to sealed. It's sealed. A ruling will be public, but that'll be in her file. Okay. So we're going to go over here. We got some breaking news and some other things we're going to catch up on. But welcome to our newest viewer. I hope you like our channel enough to subscribe. That would be a huge blessing. I would like to introduce to you Honey, Angela, and June. They are our fabulous mods. We love them. Gratefully love them. Can't do this without them. Hi, I'm Ada Kay. I am a deaf courtroom commentator. I can talk, but I grew up hearing and became deaf over the last 15 years. So sometimes you'll see me signing when a deaf person pops up, what we've not had for a long time because the deaf person that used to watch had to change their jobs. So we'll see. But anyway, welcome aboard. We're going to hop over to the Rick Reiner arraignment scheduled this morning. There is finally video. We were watching a brief short of it. I wasn't sure if it was the old one or the new one. So we're going to watch that quickly. I am going to do the little zoomy thing. I'm going to speed up just a hair. And we're not going to sit and listen to commentators. We're going to go straight to court. Come on. Let me grab them. Okay, here we go. Here's court. And it is frozen. Let me get it going.
Good morning, Your Honor.
Thank you for changing my thing, June. Or Angela.
10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principal objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
I don't have a list. I'd like to get a copy, and I can see the proof of service, but I assume the court.
Counsel for 4 and 10 present?
Yes, Your Honor. Number I am.
Number 10.
Okay, we're going to run it real quick, but we also, hold on, don't go anywhere because we have breaking news. Well, thank you so much for hopping in. I hope you hop back in. I hope you pop in and pop out. Sorry. Couldn't refuse the popcorn joke. Thanks for joining us, Boo. Have a great day.
If that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are here to issue a hold of money touch.
Counsel for number 4?
Thank you. I'm giving counsel number 10's statement. I don't see the necessity for issuing a body attachment. I too will stipulate the jurisdiction without necessarily waiving any objections we ultimately may make. But given my newness to the matter, I don't see the necessity of having a court order issued against an individual in this circumstance.
Thank you, Your Honor, and just to be clear, we do also reserve all of our objections.
Yes, and so, but as to the remaining numbers, that's 1, 2, 3, 5, 6, 7, and 8, those, the court will issue body attachment and hold it until the next court date.
And 9. Thank you. We have no objection to counsel's representations, given the fact that both have graciously submitted to jurisdiction with regard to 4 and 10. We think that's appropriate.
Thank you. Once again, the court will issue and hold 3, 5, 6, 7, 8, and 9.
Thank you.
Until the next hearing date. And we'll
Does the
seal,
court have a list?
it does. The court will seal that list as well.
We've asked
People have a copy or?
We've asked that the court seal it specifically because it is ongoing defense investigative data or evidence that we recover or we get our counsel on behalf of Mr. Reiner gets, and that is discoverable. We'll comply with all, or counsel will comply with all discovery obligations at that time.
Can you address the council's request to provide a copy to the people?
That's the point. We think that should not be done because that would implicate ongoing investigative efforts by the defense. And it would compromise Mr. Reiner's right to a fair trial and his right to maintain his investigation with some level of confidence or confidentiality, I should say.
So at this time, the court would just seal until the next court hearing date.
Thank you.
And how else would you like to proceed?
Your Honor, at this time, I, on behalf of Workman Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers and the explanation that we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here. They're staffed. They're ready to take over. My understanding is they are ready for the appointment immediately, forthwith.
Good morning, Your Honor. Kimberly Green from the Public Defender's Office. That is correct.
So the court will case, and so that firm is relieved as counsel of record, and the court appoints the Public Defender's Office to represent Mr. Reiner.
Thank you.
Current counsel turnover, any items that they received.
We will absolutely comply with that. We've already begun. The mediation has been met.
Your Honor, there's a protective order issued by the court in place regarding the handling of discovery. Order that's remained in place for now, and we will serve a copy of that on the Public Defender's Office along with the discovery we provide.
Yes, the court will order that order.
Me from Mr. Bailey raises a very sage point. I'm under a protective order not to provide our discovery to anybody else. That would text providing the information only to Ms. Green in her office. Then I can be in full compliance with the protective order.
Anything to the people, any response to that request?
No problem. I believe the protective order spells out that it covers Mr. Jackson's firm as well as any successor counsel.
Thank you. So you can provide everything to Ms. Green.
Thank you.
Thank you. Anything further? Back on the record in People versus Nick Reiner, case number 25 CJC F08098.
In 20, Kimberly Green, DRTE, from the Public Defender's Office on behalf of Mr. Reiner, who again is present.
Thank you.
Good morning, Your Honor. Khabib Bailey, representing the people of the state of California.
Thank you.
Your Honor, with the court's permission, we'd ask to put over the arraignment one last time to February 23rd, if that date is appropriate.
That date is fine, the court.
Thank you, and I will work with Ms. Green to get her discovery prior to that date.
I'll take a waiver for you. Entitled, you have a constitutional and statutory right to a speedy arraignment. Your counsel, Ms. Green from the Public Defender's Office, is requesting that your arraignment be continued to February the 23rd, 2026. In this department, do you waive your right to be arraigned today so that your matter may be continued to February 23rd, 2026 for arraignment?
Yeah, I agree.
Is counsel doing that waiver?
I do.
The court finds that the defendant has made a knowing and intelligent waiver of his right to a speedy arraignment, and that his counsel of record joins in that waiver. Matter set for arraignment in this department, February 23rd, 2026. Bail remains at no bail. Anything further?
No, yeah.
Okay, thank you.
Thank you.
That's the end of that one. So I'll loop it.
This is your right producer, Keith, for the court proceedings.
Set up. We're ready. So calling People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court out of custody. I'm sorry, in custody.
Thank you.
Good morning, Your Honor. Khabib Bailey for the people.
Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principled objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that audio attachments be issued.
I don't have the list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Did counsel for 4 and 10 present?
Yes, Your Honor. I'm not sure which number I am.
Number 10.
I'm counsel for number 10, and we do object to issue if that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are.
Sorry, my son's going to work and just discovered, unfortunately, it's going to be a hard night. He's got 3 new people. None of them know how to close, and he's the only closing person there that knows how to close. So, wow. Okay, so I want to hear from. Does anybody come out and speak? I guess not. Okay. So now we have some breaking news. Breaking news. Ooh, I'm hot in here.
Video and come away with different takes on it.
They sure are, no doubt, Amy and Simone. This was a witnessed incident, and there are several.
So this is This is a Minneapolis ICE shooting.
Different videos from slightly different angles. So clearly, people were out there videotaping what was occurring. I know you just played the video without audio. I have in the newsroom listened to it, viewed it, and I think as the mayor and the police chief filled in some of the holes during their news conference. It appears to be a woman, again, an observer, if you will, or certainly someone who was perhaps they had their car perpendicular in the roadway. It appeared that officers went up, ordered her to move, then ordered her to open the door, and that is when she took off. There is an agent, the ICE agent, who eventually pulls the trigger several times in the roadway, and this is where, depending on how you look at it, depending what agency is looking at it, you certainly heard the mayor called DHS's version of events BS. There is an agent in the roadway. There's an open window. Car sort of gets moving, peels out. I want to be careful with my verbiage. Makes a right turn. The agent open fires into the window. That car rolls down the road just a little bit further. And that is where it crashes into another vehicle, and they eventually get medical care. And as we now know, the 37-year-old woman perished. She died from the gunshot injuries from that incident. So there is video. The investigation will obviously play out. And Ryan, in our booth, wants to tell me now that we can play it with some audio. Why don't we roll that for you now?
No! Shame! Shame!
And there it goes. We're just going to play the very initial, seconds or so there. But there's this apparent effort. Perhaps ICE was moving down the road. You could see that one, I believe it's a pickup truck. Yeah, the pickup truck, that's ICE trying to get down the road. The woman again begins with a car in a perpendicular position. I don't know how exactly that would have happened, but she did appear to perhaps be blocking ICE's progress towards a target, towards a destination. I don't know. The agents got out. They were angry. They ordered her to leave. They reached for her door a couple of times, and that is when she kind of peels out to the right, and then there is an agent right there who opens fire into the window, and she is subsequently killed. So this video will be closely scrutinized by people on all sides, investigators. The Hennepin County Attorney's Office has chimed in with commentary about wanting a local investigation. We heard during the news conference that the FBI with the BCA will take a look at the investigation, the use of force. Authorities at that news conference didn't appear to know exactly what could transpire on a potential charging decision when you have a federal agent working an operation in the city of Minneapolis. But no doubt, Amy, Simone, this was very much a witnessed event, a documented event. And now, whether you call it finger pointing, clearly there's anger. There was an emphasis from the city to get ICE agents out of there. They were the targets of the protests that quickly developed around there. Karen Scullin was out in it. Chemical irritants needed to be used to at least push back some of the gathering crowd. And it didn't make the news last night, but we had in our newsroom took a look at an incident yesterday where we now understand there was a car crash where ICE perhaps was pursuing somebody out in Eden Prairie. And there was a car crash from a fleeing a target, we believe a target of the ICE investigation. There was a mashup at an intersection there. And I saw some of the aftermath video from witnesses who quickly turned their disdain and anger and angst towards the ICE agents. People very much concerned over these last several weeks since the surge began about the way ICE conducted its business. You know, the chief warned that this day could happen, and clearly now the city of Minneapolis is responding and reeling from what took place there in the Powderhorn neighborhood earlier this morning.
Yeah, that's what's so ironic is, you know, Police Chief Brian O'Hara just hosting his, you know, year in review meeting yesterday for 2025. And he literally, in that same press conference, just said his fear is that something of this nature, of this capacity, could happen. As we know, you know, they have said this is the largest immigration enforcement operation that we have seen. 2,000 agents deployed here to the Twin Cities, and now this happens here today.
And when you don't have a system of communication, right? It's a federal operation and there are agents coming in from other states. We know just from talking with some police chiefs that in Minneapolis and St. Paul, that there are local federal agents that they know and they work with often, but then others are coming in. Some other ICE agents are coming in from other places. They don't know them. And there is not an infrastructure of communication intentionally by many, including cities like Minneapolis. So it kind of felt like a recipe for disaster is what, you know, the police chief and mayor have been saying, Paul.
And the city officials have sort of made the point that, you know, this isn't necessarily in their minds about safety. There's no collaboration. You know, do we need to chase people down the street? These are, you know, perhaps people who have entered this country illegally. Are there other ways to go about an operation to take the dangerous ones off the street? Seeing them at courthouses, at immigration check-ins, at you know, visiting them at their homes, and this is what city officials worried about, you know. But we don't know exactly what was taking place this morning, but there was some operation where ICE, you know, people are being, you know, you follow them on social media, people are literally, you know, shadowing ICE as they leave their headquarters at the Whipple building right by the airport, Bloomington, that South Minneapolis little corridor near the airport. People are following them. People are watching them. People are watching their every move. Wouldn't shock you to see somebody perhaps try to block a roadway if they felt someone was trying to get away from an ICE traffic stop, if that is in fact what occurred this morning. It's creating dangerous situations is the argument from City Hall. I don't think this is a proper way to go about an immigration enforcement. And today it is the nightmare ending that the police chief has spoken about, that the mayor worried about, and now this. And then we'll have to see how the community responds. I think getting ICE out of there from what they're calling a crime scene now, right? It's a crime scene now. There's an active investigation into law enforcement's use of force. It's a new territory, certainly for the folks involved. The mayor, who's the attorney himself, didn't quite know exactly sort of the legal processes here that take place. The FBI and the BCA now probing the shooting itself. I think it's important to reiterate there are videos. There seems to be videos from several different angles, and the shooting itself. And then, you know, Fox 9 has chosen to show it, you know, sparingly and perhaps without the audio because there is, you know, obviously a woman killed in the frames and vulgar language left and right. And it's just a difficult day now for that Powderhorn neighborhood. We were just flying over in that video we showed you a second ago.
Yeah, and in that video, we saw several people of the community. And as you mentioned, we don't know how the community is going to respond to this. And we know the mayor's hope, the chief's hope is that people remain calm and remain safe as well. Paul, thank you for talking us through some of that video there. Please stay with us. I'm sure we'll check in. We have so many videos to go through in our newsroom. So glad to have you with us.
Okay, guys. Yep. We're going to have to I'm going to be doing some investigation on some of this. Excuse me. My throat. Going back over to give me a minute. So we've already talked about Alan Jackson declaring that Nick Reiner is he does declare that he's not guilty, but he also has stepped down from the lawyers team. We talked about the Officer Ice fatally shooting. So that's some breaking news. We've had the arraignment. Reiner's arraignment is postponed till February 23rd. We had the meeting or the hearing for the Uvalde CISD situation. They've come to a meeting of the minds that there was a violation, however, it was not malicious, and that they are going to continue the cross-examination and redirect, and the defense is going to be given ample time and afford the ability to address the to impeach, basically. And then from there, tomorrow there will be more hearings in court at 9. So we will be back tomorrow for court in the Uvalde Adrian Gonzales trial. That is our primary. Tomorrow is the 8th. We also have the Desmond hearing that is still going on. We also have the Davian Michaels sentencing tomorrow. We will be doing that. Hold on, Matt. You gone? All right. Love and blessings. He was at work at 7 this morning, and now he's got to go back. He had a manager's meeting, got home, and then now he's got to go back. That sucks. And he's closing, so he won't get home till 2 a.m. So anyway, but the sentencing anyway is from 11 to 12. What? So anyway, we will be definitely watching the Devin Michaels sentencing and doing the Adrian Gonzales tomorrow. As always, mods, bless you. Thank you for all you do. Welcome to the new people who came in. Thank y'all for coming in. Thank you so much, even more so importantly, for those coming back and staying with us, all of our normal everyday people. And I put you guys at the highest level of thank yous for you guys keep this channel alive and going. So if you have any questions, you may reach us over at our Discord. I'm going to throw up that little doodad real quick. There is our Discord. You may go to the Discord. We have a lot of fun things. Please validate your account. Then you can access all of the members, Discord member files and fun stuff. Also, what else am I thinking? I think that's it. It's a semi-pretty day outside. I'm going to go try and get some work done. I got to get a lot of done because I start college again. January 20th is the first day of classes for me in the master's program. Yep, I'm still a college student. Yes, sirree. All right, guys. Miigwech. Have a great day. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.